Regular City Commission meeting. This is Tuesday, January 14th, 2025. Lauren, could you call the meeting to order? No, I'm calling it to order. Can you stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please stand for a few moments of silence. Thank you. Lauren, can you do a roll call, please?
Commissioner White? Here. Commissioner Bond?
Here.
Commissioner Bigelow? Vice Mayor Commissioner Wilson?
Present.
Mayor Commissioner Osmer?
Here. Thank you. We're going to start off with the presentations. I'd like to call the Pinellas County Sheriff's Office to the front with their report. Good afternoon.
Hey, good evening, everybody. I'm starting to fly with the Sheriff's Office. I am the new supervisor to the beach for this next 6-month cycle here on our rotation. So you'll be seeing me around and my Corporal Munoz. So we'll be in and out. If you guys need anything, please don't hesitate to reach out to us. So I have the stats from December and the year to date. So December we had a total of 3 property person crimes. That's it. So pretty solid there. We had 111 total year to date. That included 1 robbery, 41 assaults, 9 burglaries, 50 larcenies, and 10 vehicle thefts. So doing pretty good with crime in the city. We had a total of 7 felonies, 6 misdemeanors, 4 warrants, 3 traffic misdemeanors for a grand total of 20. It was a total of 10 people arrested in the city. That's it. December, we had 155 traffic stops. That included citations and warnings. I'll go over your top 7 here. So traffic stops, 155. Directed patrols, 113. We had 71 911 hangups. 37 house checks. 24 assist citizens. 15 vehicles abandoned, and 13 ordinance violations. We had a total of 2 crashes in the city, one at 497 20th Avenue and one at 809 Gulf Boulevard. And those are your 2024, December 2024 stats. Anybody have any questions?
Does anybody on the commission have any questions? I actually do. You said that you have possession of controlled substance for 6 different people.
Let's see. Possession, yes ma'am. 6 charges of possession of controlled substance. I don't know if it's 6 different people necessarily. And then 1 possession with intent to sell or distribute. And
then, are those hard drugs? Is that fentanyl? Is that heroin? What is that?
It depends. Typically, I mean, probably not fentanyl, but
Right.
it could be. Yeah. So any of the hard drugs, cocaine, fentanyl,
Okay.
Things like that. It could have just been marijuana. It's still illegal in the state, so unless you have your medical card.
Okay. Thank you. Those are questions. Thank you for your report.
Thank you. No worries.
Next, I'd like to call up the Pinellas Suncoast Fire and Rescue District. Do we have someone here tonight? Is there anyone here from Pinellas Suncoast Fire and Rescue District? No? Okay. Well, then I'll move on to the Hurricane Helene and Hurricane Milton recovery update. Greg?
Good evening. I just want to cover a few things and I'll turn it over to Hetty and Fred from Civil Serve. So this will serve as my report tonight for hurricane recovery. and also will serve as my report, the city manager report of the agenda. One thing that I want to acknowledge is that we recognize this week Captain Mike Liner with the Pinellas County Sheriff's Office. Mike, after 30+ years, is retiring from the Sheriff's Office. We presented him with a plaque a few days ago. I just want to thank Mike for over a decade's worth of service to Indian Rocks Beach. He's been a pleasure to work with. As it relates to the storm, we consider to work through our insurance claims and final estimates in an effort to begin the reconstruction of the damage that was done to City Hall and the warehouse behind City Hall. That's an ongoing process, and we hope to have our permitting paperwork submitted to the county in the next couple of weeks. The Nature Preserve, after 2 years of the commission approving a budget for renovation and updates to the Nature Preserve boardwalk, that is complete. In the next few days, we'll be repaving the parking lot. There's some minor maintenance work we need to do in the restrooms, and then I'll be coordinating with the commission to be doing a reopening of the Nature Preserve, particularly the boardwalk. That's a 20+-year-old facility. I think you'll like what you see when we open that back up, and we'll be announcing the date that we're going to do that soon. The Pinellas County Beach Access Park is in the final stages of getting it back open. We hope to be able to open it up by the end of the week, what we're shooting for. Beach accesses, out of the 28, there's 4 remaining that we're doing some work on, and we hope to wrap that up soon. Civil Serve, which Eddie, Harmon, and Craig, they will make a report, give the commission and the public kind of a general update about the permitting process. And one thing I wanted to announce is after the 3-minute public comment period that will come up on the agenda soon, Eddie and Craig and Dan and Dean are going to step over to the Hemingway room, and if there's anybody here that wants to have some one-on-one time with Eddie and Craig about permits or the review process, we're going to add that tonight so people can step across the street if they want to have some time with them tonight. So I'll turn it over to Eddie and Craig for their report.
Good evening. Round 2. Good evening. Craig Fuller with Civil Serve Design Group. So we are actively receiving a lot of permits now, which is fantastic. That means you guys are rebuilding, things are coming back. At this point, we've now received and pre-permitted with the county 236 separate permits. The team with the county themselves, who was doing we'll call it initial determinations, the substantial damage determinations, they are still working through the SDEs. We are up to a total of 774 total, with 442 non-SD, while 332 are SD. There are 120 more that we've received. Now, I just want to caution, because I received a lot of questions about that just today, just while, some residents that were here. That's the initial first blush. We're estimating, based on what we're seeing, is a far lower number as far as percentages. So if you challenge it and you give us a complete application, again, we can go through that in the other room right now. We wouldn't have time to go through all the parts and pieces. I'm not saying it's easy, but it can be done if you believe and you are correct that your house is not beyond the 50%. It's likely it's not. It's just you have to prove it. There's a lot of evidence that is required behind it, not just dollars, but cost breakdowns and photos and descriptions and measurements. It's a lot. I'm not saying it isn't. On the next one, we have 220 of the initial applications that have been completed and pre-approved for the county permitting. 16 are for demolition only, while one was for windows, one was for roof, one was for plumbing. 68 additional are hanging out and require some additional information. We are not, again, we can't promise that all of these will come in under SB. We know there's a certain percentage that are substantially damaged. We know that. We're doing whatever we can to guide you through the process. We can't promise anything, but we are trying to at least get you through this step so you can move forward with rebuilding as you need to, and your life can hopefully one day go back to normal.
Hi, I'm Penny Harmon with Civil Serve. I know we've gone back and forth on process over the last 2 months. Things constantly are changing. And what we are going to do going forward, like Craig said, we're not going to use the SBR evaluation email. Everything's going to go into the Hurricane Restoration Pre-Approval email. We are going to look at your permits and then we'll review them. Your cost breakdowns and that item. Now, the big thing that has come up recently is the condos. I know a lot of the townhouses here got approved, for the entryways and, got permits for that. Well, as long as they submitted it right away. If they waited a month or two, then you have to, get my whole detailed substantial damage review. Plus, they have a condo form, or the townhouses have to divide up, make sure they know their value to divide that up. So if you have a condo, the HOA's got to be involved. To designate your value. The townhouses can be just divided up if you own the land below it. So that's a new step that's come up. I'm seeing a lot of those. And even if you need your windows replaced if you have no damage to your unit at all, you still have to go through the application process at this point in time with all the forms, everything, even interior remodel, on the upper floor of a condo, anything, you have to go through the whole process. And with that, we'll be answering more questions after this. If you have any more detailed questions on that, I appreciate it.
That's all? Okay, thank you. Now we'll open up the public comment. This is a 3-minute time limit per speaker. If anyone's up there talking, I would prefer that everyone stay silent while they're talking. I don't want any clapping. I don't want any big outbreaks of anything. Just let that person talk. We do have a court reporter here tonight, and we're trying to get this all recorded. Any member of the audience may come forward, give their name and address, and state any comment or concern that they may have regarding any matter over the city. The commission has control, excluding the agenda items. All statements made to the city commission shall be made to the city commission as a whole, not directed to any individual city commission member, and no personal, impertinent, or slanderous remarks shall be permitted. No speaker shall be interrupted, and no debate shall occur between the speaker and the city commission. Who would like to speak first?
Before we have our first speaker, as I suspect we have people who have not been to public hearings frequently or recently, at this point it's anything that's not on the agenda, so if you're here to discuss anything about short-term rentals that is on the agenda, you will have a time to speak about that. We're not silencing your ability to do that, it's just timing and flow of the meeting. So if you wish to talk about anything that's not short-term rentals, now would be the time to go. Thank you.
Hey, Don.
Hey, Don Hess, 2104 Beach Trail. So, most of y'all know I used to build nightclubs. I was building a nightclub in Lafayette, Louisiana one time. And it was about 2 blocks south of a college there. And I asked the guy that owned the bar, I says, what's the name of that school? It says USL, and he had graduated from USL. I says, what does USL stand for? It says, the University of Slow Learners. I'm hoping that that doesn't apply to what's happening with our city commission and our county commission also. I was leaving my house and I picked up 2 Christmas cards to throw away. One was from Financial Advisor, and one was from USF PAC Study for Aging Successfully. Like, that's never going to happen, right? But other thing that was in the mail was a easement that the county wants us to sign. Those of us that live on the beach, I live on the beach. So they want us to sign putting sand on the beach. This is coming back around. I read it, I would bring it to you, but I read it and I threw it away. But I did call John Bishop. Y'all know John Bishop? Okay, good. So I called John Bishop and I said, you know, we're not gonna sign this. And he says, well, we have another version. And that version has no dune building in it, okay? And so, I haven't seen that. I did ask for it. But I hope that this city, this time, none of y'all live on the beach or own property on the beach. So, but I hope that y'all will work with us that do live on the beach. Maybe that easement is palatable. He said, the first thing he says, Don, you're not gonna trust us. And I says, well, maybe not, but let's figure out what's going on here, you know? Because if it doesn't have any dune building, by the way, how did those dunes work out last time? You know, I always said dunes are nothing more than a sandcastle waiting for high tide. And I think, I hate to say this, but I told you so. So the problem is, when that happened, even though I had no damage from the storm, no water in my house, nothing like that, it still cost me $15,000 to get rid of the sand that washed up because of, or blew up, or however it got there in my front yard due to the sand, doing the thing. So we don't need another dune boggle. We don't need that. I hope the city realizes that, tries to work with us, and tries to work with us on the beach. So maybe we can augment the beach, nourish it, make it wider. My front yard, my beach looks like Chamber of Commerce should take a picture. It's the best it's looked in 40 years. So thank you, Milton. No one else in this room is going to say that, I can tell you that, but the beach came out really nice. So if we can, as these easements come out, you can work with us. Thank you very much.
Thank you, Don. Who else would like to speak this evening?
Hello, I'm Hillary King. I live at 327 Bahia Vista Drive here in Indian Rocks Beach. My comments are really about the commission. I'm actually running for a commission slot, and with apologies to our incumbents that are also running. I would really just like to introduce myself basically and get to know some of you at this level and open up. I'm really happy to meet anybody after that would have anything they want to discuss with me. I've never run for anything like this before. I will tell you a little bit about myself. I've been in Indian Rocks Beach for 10 years. I love this town. It's amazing. Grew up in Treasure Island, so really familiar with coastal communities and the balance we're all trying to get between residents and our tourism and our businesses. So that's important to me that we find that balance. I'm an electrical engineer by education, but a 35-year aerospace industry leader. My last part of my career, the last probably, I'll say 15 to 18 years, I ran businesses that were well over $300 million in annual sales. So I do have a business background. I think that's going to be an important thing for me to bring to anything I can do to support the city. I really like to see cities governed actively. I like to see community involvement and engagement. I lived for a very short while recently in Seattle, went there for some work opportunities and came back in about 2021 to work from home. I was a little bit surprised when I came back to see how much had changed between 2018 and 2021. COVID notwithstanding, I mean, I know that was a big influence for many towns. But I felt like there was a big drifting away from active resident involvement in the city, and for a lot of different reasons that I won't get into because I don't want to touch on an agenda item and get kicked out. But anyway, I would like to just express my, my desire to work in an active governed city and to make sure that we're asking all the right questions, that we're finding the balance, and that we're looking at all the risks and the opportunities for the balance of our population here, whether it's the residents, businesses, et cetera, to make sure that we're an open city, that we do encourage tourism, but that we also are very much respondent to what the residents' needs. So thank you very much. Appreciate the time.
Thank you. Good evening.
Good evening. My name is Richard Alvaro. I live at 310 La Hacienda Drive. I'm probably one of the oldest residents in the city now. I lived here for 39 years, and my problem is with these severe damage things. Why is it on the onus of the property owner to prove that his house was not severely damaged? Why isn't it up to either the building department or somebody else to come in and physically examine the building? Now, I got my notice that my place is 88.1% substantial damage. That is a lie, and I'll challenge anybody to tell me different. Now, I've talked to Mr. Twitty, and I told him I would like somebody to come and, really inspect my property. Show me where it's 88.1%. That's ridiculous. Me and my wife have lived there ever since the storm. We have 2 operating bathrooms. We have full electricity. Our air conditioning works. Our heater works. I got a fairly new roof. None of our walls have fallen down. My floor is fully intact. I mean, it's ridiculous. Whoever's doing these appraisals has no idea what they're doing. That's all I got to say. Thank you.
Thank you. Anyone else?
Hi, I'm Scott Ayers, 108 8th Avenue. I wanted to talk tonight a little bit about affordable housing in Indian Rocks Beach. I'm not an out-of-state Airbnb owner. I'm not a corporate person. I'm a resident who also has a few units that I manage and make available at very affordable prices to people in the community of Indian Rocks Beach. When Helene hit, 2 of the tenants that I lost one was a retired woman who was caring for her disabled daughter, adult daughter. Another one of the tenants I lost was a single parent with 2 children. Over the years, I've always tried to rent to people that are most vulnerable in the community that needed a place to live. In the years past, I've had 2 police officers who resided in my property. I offered them below market rates so that I could bring a police officer to live in our community. I've had numerous nurses. I've had retired veterans. I've had disabled veterans. I've had disabled people, numerous disabled people who've been residents. And on my 3 properties, I've gotten a letter so far that 2 of them are beyond repair and need to be demolished. If this goes the way it's going to go, what's going to replace them is not going to be affordable housing. And so the opportunity to have our community well-rounded with a diverse community is going to go away if the people who are trying to provide affordable, simple housing in Indian Rocks Beach are done away with. Thank you.
Thank you. Anyone else like to speak this evening?
How you doing? Antonio Pereira from 1400 Big Pine Boulevard. First, want to thank everyone up here and everyone who showed up. I'm fairly new to the town. Enjoy it, love it down here. It's what we called home. So my biggest concern here is more with the SD in the building permit process. First, on the SD side of things, I've been told there's a FEMA calculator that figures out how we become SD or non-SD, and that calculator doesn't seem to be readily available for people to examine or determine that. And so therefore, most of us have had to go out there and get our independent appraisal at our own cost to just prove down what most of us already know. And I understand there's the battle between FEMA approved insurance and staying viable to that as a town is important. But at what point are the residents important? And that goes back now to the permitting process. I applied for a permit prior to my SD letter back in early November. I've gone through multiple stages of reviews, online reviews. Many of times they come back 30 days later telling me that I don't have enough information. What information is missing? Not given. A lot of times they'll tell me certain documents were incomplete, but no information what was incomplete. So it becomes you figure it out yourself type of situation as a homeowner. So I've gone down to the building department in Clearwater, sat with them, have filled out the report side by side with individuals there who have been super helpful. And I understand they're under extreme stress also, just like us as owners. But I re-enter these documents and it goes through a review cycle that seems to be taking about 30 days. And I know for most of us, we can't afford 30 days. We can't continue to pay for hotels or lodging or living outside our homes. We've already done that through Christmas, through Thanksgiving. And I understand they're understaffed or just there's more requests than they've ever had to deal with. But what are we doing? I've emailed many people. Times I get no response, times I get vague response. I've gone there. At what point is the town liable to go out there and answer some of these requests? I just want to know where we are, as most of the people here want to know where we are. So again, I thank everybody. I know a lot of you guys do this not as a full-time job, so I do appreciate everything you guys do for the town, so that's it.
Thank you. Anyone else have a comment? Hey, John.
Hi, Dr. Scampi. John Fansfield, 448 Harbor Drive South. Here's something that should be shocking to you. The following was posted on Facebook to a group of SDR investors to give them a heads up in regards to the scheduling of the sudden and unexpected to us agenda items of this meeting. Let me quote from it. This time around, the city is skipping the workshops in hopes that they will avoid the backlash from the HNH crowd. This was one of our suggestions. This reveals to us that the investor group was working with person or persons in the city to minimize resident impact by skipping a public workshop prior to tonight's first meeting. Think about this. City officials colluding to minimize citizen input on an ordinance that could severely change the city. And that's not all. It continued, again I quote, "I will share the newly revised ordinance as soon as the city releases the agenda. The agenda should be out in the next day or so." In other words, this investor group was given prior preferential notice of what was going on the agenda by the city or the commissioner before the city released it to the public. I hope these revelations really bother you. I hope you have the guts to find out who is responsible for this and hold them accountable and then inform the public for transparency. Because this sudden surprise agenda, skipping a workshop to minimize resident input, and giving prior preferential notice to one side before giving it to the public, these stink. They smell of collusion and dirty dealing. Once the commission and the city loses the trust of the voters, it's hard or impossible to get it back. So find the source of this malfeasance to make sure it doesn't happen again. It may involve serious sunshine law violations or arbitration violations. Thank you in advance for your attention to this. I hope you don't sweep it under the carpet. Thank you.
Thank you, John. Oh, stop. Next speaker.
The microphones. Hi, my name's Kelly Citrick.
Sorry, Kelly, if you could just hold the one that's got a cord attached to it.
Oh, okay.
Thank you.
Three to choose from. Okay, my name is Kelly Cistrick. I live at 448 Harbor Drive South in Indian Rocks Beach. And I also have some concerns about the scheduling or the lack of scheduling of workshops. I think we should be in a workshop this evening. Our city normally does a good job communicating when there's major issues of importance. Residents have gotten postcards in the past before the vacation rental issues or waterway issues. And tonight we should be having a workshop on these lawsuits, not rushing to a first reading. There are financial impacts to the city that need to be discussed. There will be FEMA reimbursements eventually coming back to the city, and a new tax year next year, but I'm sure there are some loan programs and other things that the citizenry would like to hear about in the meantime for financing. I don't want the commissioners to be concerned that we're going to go bankrupt in the next 6 months, because I know that there's some other alternatives out there. And there's a new lawsuit on the agenda tonight that's not even described properly. It's a state lawsuit for $2.6 million for a Bert Harris claim. That should be part of tonight's workshop, not rushing to an ordinance change on the vacation rentals. So, thank you.
Thank you, Kelly. Would anyone else like to speak?
I'm just trying to clarify, if we want to talk about short-term rentals, we can do it after this. We have an opportunity.
There are two agenda items on the agenda this evening, both having to do with short-term rentals in different respects. Those will be discussed and introduced by staff and the commission, and you will have an opportunity to comment before any official action is taken, as is contemplated by Florida law.
Thank you very much. We just want to clarify why.
It's a delicate balance on this side of the equation, giving each person an opportunity to speak and not presume where the comments are going.
Thank you very much.
Welcome.
Thank you. Hi, my name is Kelly Watt. I live at 431 Harbor Drive South. Thank you for letting us have a comment period today. I would just like to echo what the last two speakers have said. I sent an email to the commissioners and to Randy and to Greg expressing my surprise that there was no workshop scheduled for these topics tonight. This is a heated topic. We spent years working it out. I don't understand why a workshop wasn't scheduled. That seems to be our normal standard process, and there seems to have been a deviation from that normal standard process. And I would like to know how that decision was made and who made that decision. Thank you.
Thank you. Anyone else? I will be closing the public comment, and we will move on to the reports of the city attorney.
Thank you, Madam Mayor. I'm not going to report on anything that's on the agenda this evening. If we could turn off the other mics that aren't in use when they're not in use. I won't be speaking on anything at this point that's on the agenda. The legislative session is scheduled to begin in March of this year. Before I continue, I just wish to remind anybody present that Hetty, Harmon, and Craig will be available to answer questions if you're here with specific concerns related to permitting, FEMA. Otherwise, I don't wish that to get lost in the shuffle, that staff is available if you wish to speak to them on those issues. As for my report, the legislative session is scheduled to begin in March. Yesterday, the governor announced that he may be trying to call a special session sooner than that. Among the issues there, one was some effort to seek legislative mandates for local government in their role in any forthcoming immigration policy from the incoming administration. So that may have impacts on our operation here. There's been some discussion between the various branches of government as to whether that'll move forward or not. Of course, we sit lowest on that totem pole, and we'll take our direction from the based on how those events develop. But I do wish to make you aware, absent a special session, legislative session starts in, I believe it's March 7th, 2025. Interestingly, though I am not a soothsayer, it's entirely possible something is filed that fundamentally changes the landscape of what we're discussing tonight. We need to be mindful of that as well. But that said, outside of reporting on that, I have nothing else to add at this time, Madam Mayor.
Thank you. Now the report of the city manager.
Madam Mayor, I don't have anything at this point.
Thank you. We will move on to the city commission. Jude, do you have anything this evening? Thank you. Commissioner Wyatt?
I do not have anything this evening.
Vice Mayor Wilson?
I would just like to remind everyone that in order to sit on this commission, we must be residents of Indian Rocks Beach. And because of that, all 5 of us were also in some way impacted, depending on the type of our residency. I had 28 inches in a townhouse. Luckily, I got that permit in there pretty quick. But it's very hard to have people say that we're not empathetic that we don't understand what's going on. Please know, we're going through the same process. We filled out the same paperwork. I got that same heavy letter. I spent that same 6 hours at Clearwater to get that permit. So please know, we do understand, and we are in there in the process also. Thank you.
Thank you. John Bigelow, do you have a report this evening?
I don't have anything to add tonight since I'm on the town.
All right, thank you, John. The only thing I'd like to add that I have read everyone's emails. I am getting your information. I don't know that I agree with all the information that's out there. I know that some things that you may have received or read sound like we're in some kind of special cahoots with someone I've never talked to. I don't even know who it is. And I promise you, everyone sitting on this commission has not taken anything or any information from any investor in this town. That's not what we're up here for. It's insulting to hear that somebody wrote it in an email and it automatically makes it a fact. Because it's not a fact. It's not a fact. I mean, this is going to be a tough evening. We've got some tough decisions to make. And it's not going to be easy. But we are a vacation community. And I can't change that. If you go to the IRB Museum, you'll see how long we've been that. And that all of our restaurants and business owners can't survive without visitors.
Yeah, absolutely. Doesn't change that.
No other comments from the commission? Thank you. Lauren, do we have any additions or deletions?
No, we do not.
Right. I'd like to move on to the consent agenda. Randy, would you read?
Madam Mayor, there's one item on the consent agenda. Item 5A, approval of the December 10, 2024 regular city commission meeting minutes. This is the lone item on the consent agenda, Madam Mayor.
Could I have a motion?
I make a motion that we approve the consent agenda item.
Second. All in favor?
Aye.
Motion carries. Next, we'll start on the public hearings. Randy, would you read, please?
Yes, ma'am. Yes, Madam Mayor. The first item on the consent agenda, on the public hearing agenda is the authorization for the city attorney to transmit a Harris Act claim response. The second item is the first reading of ordinance 2025-01. We will first deal with item 6A and then item 6B, though as I'll explain in a moment, I acknowledge that these are inextricably linked. I'd like to address, or rather introduce these with context. Before I begin with the authorization to transmit the letter response to the claim and explain the claim, there seems to be great attention on how this meeting came to pass and who is responsible for it. And I can very directly tell you, the first person or persons responsible for tonight's meeting and the timing is the Florida legislature. The second person or persons responsible for tonight's meeting is the U.S. District Court for the Middle District of Florida. The third person responsible is Father Time. And fourth on that list is your city attorney advising the commission and city administration. And I'll explain the responsibility of each of those in sequence. The first is the legislature. Item 6A concerns a response to a Harris Act claim. The city received a Harris Act claim on November 5th. It was transmitted, I believe, November 5th, 2024. Under the Harris Act, which is found in Florida Statute 70.001 of the Florida Statutes, a Harris Act claim is made when an individual or property owner contends that a specific action of government has inordinately burdened a specific use of their property. When a claim is presented to a local government, that local government has 90 days in which to furnish a response. And there are statutory requirements of what that response requires. 90 days from November 5th would put us at February 3rd, approximately. This is the last city commission meeting, regular city commission meeting, before February 3rd. With all acknowledgement of travel during the holidays, of the real impact that Hurricanes Helene, Milton, to say nothing of Debbie and others, had on this community in the preceding months, this is the last logical time when we could reasonably get guidance. I could, as the city attorney, get guidance from my client, because my client cannot give me guidance privately. This is the last reasonable time in which I could get that guidance and transmit it in a timely fashion in keeping with the statutory requirements. So when I say that this meeting is had in timing because first of the Florida legislature, I'm looking to the statutory requirements in how a Harris Act claim must be handled and responded to. The second, I have pointed to the Middle District of Florida. We were sued in the summer of 2023 concerning the adoption of the short-term rental ordinance on May 9th, 2023. For those who are unfamiliar with the posture of these proceedings, we have defended this suit. We have filed motions to dismiss that we believe meritorious, and that if heard by the court, could likely result in the narrowing, if not resolution, of some of the claims presented. Be that as it may, with our motions pending, we were ordered last fall to go to, trying to remember the timing of this, in the fall of 2023, we were ordered to mediate the case by January 2024. We complied with the court's order and mediated the case in January 2024. That mediation process concluded in a tentative understanding of a potential settlement framework that took several months to negotiate and develop. And it was at all times made clear to all parties involved that nothing would be finalized absent the approval of the commission. The commission was briefed both in an executive session, as contemplated by Florida statutes, and subsequently at a public hearing held in August of 2024. We had the hearing in August 2024, and this commission did not endorse the proposed settlement. They said they did not wish to have it heard on first reading. And so that concluded those mediation negotiations. On August 30th, just 3 days later, one of the litigants in the 7 pending suits filed a motion to reopen the case. The cases had been closed administratively, not on the substance or the merits, administratively closed so the parties could explore settlement. And the court was gracious in giving us nearly 9 months to navigate that process. Ultimately, it was not successful, and the plaintiff moved to reopen the case and began serving the city with discovery, requesting deposition dates, and otherwise litigating their case. In less than a week, on September 4th, 2024, I think just after the Labor Day holiday, if memory serves, the court issued an order opening the case, and then, in the same order, directing the parties to go back to mediation. Which, as somebody who is a litigator, and I know for some of you, you are unfamiliar with me, you believe me to just sit here and write ordinances and write contracts. I am a big boy lawyer. I do litigate as well. I understand the process, and I've been successful in defending the very kinds of claims that are presented here. With a collective more than century of experience between all of the lawyers involved, none of us predicted or anticipated that the court would send us back to mediation. But it did. And under our ethical obligations under the Florida Bar and those to our clients, we had to return to the mediation table in good faith. That means you have to go to mediation and attempt to find a resolution. I cannot, based on my livelihood, go to the mediation and say, you heard the meeting, nothing's happening, we are done here. The clear indication of the court was it would like to see us continue to determine if a reasonable solution could be had. And so, the court directed the parties to go to mediation again and administratively stayed the case for 120 days. That order was entered on September 4th, 2024. 120 days from September 4th, 2024 is February 19th. If an ordinance is to be presented on first and second reading, as Chapter 166 of the Florida statutes requires, our regular meeting schedule would require us to have the first reading now and the second reading before February 19th for us to meaningfully tell the court whether or not we have made progress and not say, well, we're kind of in the middle of it still. I am a Florida native. This is also my home. I am also a human person. I also have a family who has, as in a separate community, 2 years ago, south of here, experienced similar events. This was not done with insensitivity to the plight of your community. This was trying to accommodate and balance all the equities that go into navigating policymaking and litigation. So I've told you the second culprit in scheduling this meeting today was the Middle District of Florida and the litigants' efforts to follow a court order. The third was Father Time, because time marches on no matter what we wish to do. And the fourth was me. I told my client, the city, all of that information and said, this is the best approach. I am certified by the Florida Bar in city, county, and local government law. I practice this and exclusively this for a living. I will have you know that if you look in the Florida statutes in Chapter 286, the Sunshine Law, there is no mention of the word work session. There is only a discussion of public meetings. And substantively, there is no substantive difference between a work session and a first reading of the ordinance, because the commission has every ability to consider your input, suggest amendments, vote this up, vote this down, and every single person in here has the right to be heard before they take that official act. My goal here, naive though it may be, is to protect the integrity of this process so everybody here gets due process. And so you will be heard tonight. So, to the extent there was accusations of collusion, the city's adversaries, if you will, in litigation, have the special knowledge of the fact that they were sitting in the room at mediation. And we told them that they knew all the same information as us and fully anticipated this would likely be presented on that timeline. There was no special collusion. There is no conspiracy. There is an effort to balance the equities and navigate a very challenging process. For those of you who have not seen my poor mug up here, we have had several compositions of the commission go through this since 2017 when this discourse began. Myself and Greg are among the few constants on this side of the table. So this is not my second or third hearing on this. I'm familiar with the process. There is no prior preferential treatment. It is confounding that it can be said that this community was provided no notice, and I'm looking at a room that is standing room only. We are trying to provide notice. We are trying to navigate the challenges of not adding to the pressures that people are facing on a daily basis. I anticipate fully tonight that there will be some discussion of code enforcement. Every single one of this city's code enforcement officers are people who had substantially damaged homes. We know. We are not trying to be insensitive. We are left with only imperfect solutions to a very challenging process. So the implication that a workshop has been skipped presupposes a requirement that does not exist. And were that we had all the time, we would go through that process. But we had a workshop less than 6 months ago. And once we get to that agenda item, I think it will be clear, watch your step. I think it will be clear that there are not major changes that should take this community by surprise. There is no dirty dealing. as a member of the Florida Bar, this is how I feed my family. This is how I do my job. I believe, again, perhaps naively, in this democratic experiment we have in this country. And so if you are prepared to accuse me of corruption, please come forward and provide me your specific facts, and be prepared to defend them elsewhere. I'm here trying to do a job and advise my client, 5 policymakers. I don't have a stake in this process. I'm prepared to resolve it however this community proceeds, as I've done with all my clients and as I do with all my clients. There is no malfeasance. The only malfeasance that I could perhaps contemplate is if I sat here and told you that I have the capacity to ban short-term rentals in this community, or that this commission has that power, because I never make policy. That would be malfeasance, because it's simply not true. There are no sunshine law violations. There is only process. We've provided notice. We have a full room, and each of you, thank you for taking time out of your evening to come here, and I mean that, regardless of your position. This is how we get better work product. This is how the process works, frustrating though it may be. This is the process. So, with that context, item 6A is the receipt of a claim on a Byrd-Harris Act claim. It is not a lawsuit yet. It has not yet been filed as suit. Under Florida statute, chapter 70.001, which we discussed a few moments ago, a claim is presented and we have an opportunity to consider whether this commission wishes to settle this, which we must do with every claim. The claim is that the ordinance's adoption and subsequent press release related to it that publicized its enforcement or potential enforcement renders a diminution in value to this property as an inordinate burden or restriction on an existing use of $2.65 million for the property at 455 20th Avenue. This is the only Byrd-Harris claim substantively that we have received. I say substantively because while others have suggested they may pursue a claim, we only have one claim that has been pursued to date, and it is solely for this property. This is part and parcel to the potential, nothing tonight, by the way, is a foregone conclusion, the potential settlement of the litigation brought against the city, of which there are 7 cases presently pending. The plaintiff's firm that represents the litigant, named AP6 LLC in this case, also represents 5 of the other 6 remaining litigants. They are not pursuing and have made clear they do not intend to pursue a Harris Act claim on any of those other properties. If this commission is inclined to provide me the direction and authorize me to send the correspondence that was drafted for your review, this is in fact part of the settlement, or the potential settlement. The tentative settlement proposed in total is the settlement of this Byrd-Harris claim by offering 2 more occupants from the 12 that is proposed in the proposed ordinance, understanding the current ordinance provides for 10. This property, and only this property, based on the way that Florida statute operates, would be allowed up to 14 overnight occupants. If the city offers that settlement, that case goes away. The $2.65 million, the costs, and both temporal and financial, that come with litigation. I have litigated Harris Act claims, more than one. They are not cheap cases to get through, even if you have a slam dunk. There are cases that should resolve at the motion to dismiss stage. Courts don't often see these cases, so they let them get by the motion to dismiss phase and then resolve them 3 and 4 years later on the same arguments you made 3 and 4 years ago. But hey, that's the path. So there's no guarantee in terms of the time in which to resolve. When we talk mediation and settlement in other contexts, we talk about compromise, control, closure, and certainty. That's what we talk about when we talk about settlement. and mediation. And that's what we're proposing, is a proposed solution that will give this city control over the litigation, which to this point we have not had. We have submitted motions to dismiss. They've been mooted, not substantively, but because the court is sending us go back to mediation repeatedly. So we get control, but we only get that control with a compromise, which means nobody's really happy. But hey, we found a path. And with that compromise, we get certainty and potentially closure on this chapter of this issue. No policy issue is ever forever settled. Otherwise, this would not be called the experiment. It would be considered the law of democracy. Right? It is the scientific method at play, if you will. So, as it relates to the Bert Harris claim, there's a letter that has been drafted based on guidance this commission already provided in executive session in terms of how they would like things presented, nothing being resolved yet. And to read specifically from the letter, the city offers the following written settlement offer. Notwithstanding the language within the city's short-term rental ordinances, resolutions, rules, and regulations, as they exist now and may be amended, the city is willing to allow a maximum number of 14 overnight occupants at the property, again that being 455 20th, when the property is used as a short-term vacation rental. The city is not offering any monetary payment in settlement of your, brackets, $2.5 million claim. The settlement offer is conditioned upon your execution of a mutually agreeable release of any and all Harris claims identified or referenced in the claim letter and corresponding appraisal. That is what is being offered in resolution of the Harris Act claim, and based on the discussions of mediation, I am very confident that if presented, that this would resolve, if not certain, resolve this claim. I'm not going to go into the substance of all of the ordinance yet, so as not to conflate and confuse the discussion, but that is the Harris Act claim as briefly as I can summarize it. I'm just looking at my notes to make sure I don't intrude on your opportunity to speak, and I appreciate, though some of you may find what I'm saying not of interest, that you've all given me the opportunity to clearly articulate it. I suppose the last comment I will make is under Florida's Constitution, every public officer is charged with the protection of the public trust. In fact, the Constitution states a public office is a public trust, and that trust shall be sustained and secured against abuse. While we may not all agree on the best solution here, I just ask that as you consider your statements, you are mindful that every member of this commission, your city manager, myself, we are all bound by that public trust obligation, to say nothing of our obligations as professionals, as lawyers, city managers, and otherwise. But ultimately, as it relates to the city manager and myself, we are not the policymakers. Nothing has been decided. It is being presented for public consideration in a transparent fashion on the timelines that circumstance and the law allow. So with that, commissioners, I would turn it to you to debate and discuss. And if you do not wish to discuss until you've heard from the public, then Mayor, I would suggest you open to the public. It is your meeting to facilitate.
Would you like to discuss after the public comment? Please. All right. Let's proceed with the public comment on the Bert Harris Act. Hey, John.
So the best part about having the meetings here is there's the bar right across the driveway. Good thing. So,
state your name and address.
Oh, Don House, 2104 Bistro. So if you can finish up this meeting before my bedtime, anyway, I'll pay y'all around because I think you're going to need it. I'm just saying. So this city commission has been handed a pile of crap, and it's not of y'all's doing. It was a commission before. There should be a lot more, I think, holding to the fire for that commission. I don't know why they voted the way they voted. I've tried to get answers from a couple of them. You can't get an answer. We're the only city that went this way. Out of the big C, we're the only city that went this way. There was plenty of reason not to go this way, but our city did. Y'all didn't vote that. None of y'all were on that city commission. But y'all are dealing with the crap. So, as you go to this, you're gonna make a decision tonight that's gonna piss off a lot of people. One way or the other, it's gonna make somebody mad. That's why we pay the big bucks to make those decisions. And I'll buy around everything. But what happens is, a lot of people said, I don't have a dog in this fight, because I live on the west side, I live on the beach. We've always had one-night rentals on the beach. It's always been. West side of Gulf has always been that way. But I do have a dog in this fight, because and I would like to hear Randy's interpretation of what's the possibility of financial, if something defendable. From what I understand, that the last time we had on this meeting, there were 7 lawsuits. And I said, okay, you sell with those 7, it might have been 8 at one point. Anyway, you settle with them, what about 9, 10, 11, and 12? Maybe this new ordinance will stop it all. I would like to know from our city attorney, what's the odds of ending this fiasco that y'all are not responsible for, but you have to settle it. Try and get it done, because if it's going to cost the city and my taxes go up, then I'm going to be really mad. So when y'all think about that, find out, get an idea of the financial exposure of the city, how bad it is, and let that influence your decision, because that's going to affect everybody in the city. And if it goes bad, then you would have pissed off everybody in the city. Good luck. And I'll see you for, what does everybody drink? You want me just buy a pitcher of margaritas?
Kelly? Good evening, Kelly Sister, 448 Harbor Drive South. I think really there's 2 questions that the commission has to consider regarding this Harris request tonight. And one is this property operating lawfully? And then number 2 is, why would the city contemplate rewarding this property if it's not operating lawfully as a vacation rental? If this property was operating lawfully under the 2023-02 short-term vacation rental ordinance, the property was entitled to vesting for 2 additional occupants for 2 years. So that property could advertise for 12 occupants. Now, that property is currently advertising on Airbnb for 14 occupants. So that right there is in violation of our ordinance. I transmitted a letter to Randy, our city attorney, this morning. I copied all the commissioners on it, as well as our city manager. I'm going to read it to you briefly. Are you aware that the property at 455 20th Avenue in Indian Rocks Beach is currently advertising on Airbnb's website for 14 guests? The link below is from this morning. I don't believe this property is operating lawfully in accordance with Indian Rocks Beach's Ordinance 2023-02 by advertising for more than 12 guests. Under Ordinance 2023-02, Section 18-216, maximum occupancy, there is a vesting period. If 455 20th Avenue was lawfully used as a vacation rental upon passage of this ordinance in 2023, they were entitled to a maximum occupancy of 12 guests under a 2-year vesting agreement. They are currently advertising on Airbnb for 14 guests, which violates the ordinance. How could they have economic losses under a Burt Harris claim if they are still advertising for 14 guests? I also have concerns that this property may have uninhabitable living space on the lower level. The Doring Ahern appraisal photos that were submitted by the property owner that are part of the agenda package for Indian Rocks Beach for November 14, 2025 appear to show lower level living space, e.g. a kitchenette that is also mentioned in the Airbnb ad. There are double bunk beds that may also be located on the first floor that are shown in the appraisal photos. If confirmed, I believe this would be a violation of FEMA building codes and Indian Rocks Beach Municipal Code 50-66. I would also ask that you confirm if this property has been inspected for fire safety in accordance with the City Ordinance 2023-02. Three-story lodging properties have unique rules they must comply with under the Florida Fire Prevention Code. If they are not in compliance with fire codes, how could they be issued an Indian Rocks Beach BTR number? If this property is not lawfully operating as a vacation rental business, then why would it be entitled to a Burt Harris settlement? If that is the case, the settlement offer should be withdrawn and not presented to our commission tonight. Sincerely, Kelly Cieserick.
Back again, John Fansfield, 448 Harbor Drive South. Let's present some facts about what I said earlier. That thing I held up was posted prior to the public being made aware of what was going to happen this evening. That's a fact. And it's a fact that the city government officials could have let the residents know about what was on the agenda before just last Friday. So getting back to this particular thing, Kelly actually, she mentioned most everything I was going to say. This business has been operating illegally, consistently, and yet it's suing us. And you're going to give into it. You're going to give it what it wants. We have photos, actually a movie, of the bottom floor of this building with bunk beds in it. That's completely illegal. It's FEMA. All of us can lose our better FEMA insurance rates if things like this continue. So how in the world are you going to make a concession to them and give in to them? They might not even be able to be legally able to sue us, and you're rewarding somebody who's been a bad actor from the beginning. And of course the other thing is, if this one business is given a 40% increase in its occupancy, then how many other businesses are going to be suing the city to get the same thing? It sets a very bad precedent. Thank you.
Madam Mayor, if I may, I'm not going to be in the habit of responding to public comments. I just need to address one thing that I think may inform the discourse. There's been extensive correspondence directed to you, telling you about the law, about people's legal rights, about how the judiciary would resolve issues. I don't think all of it grounded in the full context and realities of the case law. Burt Harris claims have to do with rights, not necessarily everything that's been discussed here. One thing I do wish to address, however, is the suggestion that the litigant here is operating illegally. There is a reason in terms of both litigation strategy, relating to costs, relating to claims, and relating to the city's defenses, that when presented with these claims challenging the validity of the ordinance's restrictions, in order to control the universe of claims and issues being addressed, that the enforcement as to those parties in litigation, they do not have a blank check on code enforcement. However, we have abated or suspended the registration process in full for parties that are actively litigating precisely that issue. And before pearls are clutched, allow me to explain that if somebody is challenging the validity of your ordinance, and then you continue to enforce those precise issues, you may be giving them claims they don't have. And I have to speak circumspect because my adversary is in the room. But you may be giving them claims that have not been perfected. And alternatively, you are creating work for yourself in the form of motion practice that directed to that enforcement that may go beyond those litigants. And so there are real legal strategic reasons for proceeding that way. And so that is additional context for you, commissioners, as to where we presently stand.
Thank you, Randy. Bob, you're up next.
All right, Bob Copeland, 447 20th Avenue. Thank you, everybody.
Sorry, Bob, could you use the microphone for that?
Thank you, Bob Copeland, 447 20th Avenue. Thank you for everything you've done and you're going to do. And it's a very tough spot. I've been up here many times. I have a pretty good grasp of what Mr. Moore was just explaining to you. I expect to come back and talk on the next time. So I'm not going to use the rule of 10 minutes for that people to give it to me. I would just like to inform the city that the citizens group did sue the fire department, Fire Marshal and Chief Davidson, over the fact that there's 20 out of 28 three-story properties, licenses Airbnbs, short-term rentals. Those are the only ones I can figure out. There's more. There were state mandated fire inspection, fire safety inspection. That is a precondition of the license being issued as set forth on your business tax receipt application. Today, and I have an email, and I just forwarded it to the city while we were speaking, the fire chief confirmed 100% 455 20th Avenue has never registered and never got this fire safety inspection. That's a precondition to having its license. Very simplistically, doesn't have standing to have a license. The license should be revoked. Poker, that's called Royal Flush. Chess, it's called checkmate. You have no license, you have no contract, you have no right to sue. I understand what Mr. Moore is saying. I could show you the text on my phone, but it hasn't been sent to your city site. The fire chief has acknowledged that subsequent to our suit being filed. The fire chief is the one that does the inspection for you, but it is a precondition of a valid license. So requirement under the law. I'm not going to go over the other things I sent this morning about that. I just wanted you to know that up front. Check your emails. It's from the Fire Marshal's Department. Thank you very much. I appreciate it. I know it's not easy. Game over. Royal Flush. Checkmate. Thank you.
Who would like to speak next?
Good evening, Rhett Parker on behalf of 455 20th Avenue and AP6. I'm an attorney with Phelps Dunbar. I am the individual that Mr. Moore just mentioned about his adversarial courtroom. I want to speak first on this issue and the settlement offer that's been relayed. There have been two issues that have largely been addressed by the citizens this evening. One is regarding FEMA, the other is regarding lawful use and lawful rental of the AP6 property, and I guess the third thing would also be this fire safety issue. I want to speak on each of those, and I'll keep it brief for the 3 minutes that I have since I'm only speaking on behalf of AP6. In regards to FEMA, as some of you may recall, there was actually a notice of violation of that was issued to AP6. There was an inspection. There was a litigation process in front of the special magistrate. We were given 180 days to become FEMA compliant. We did that. We ripped out the bottom, we became FEMA compliant, there was another inspection, it passed the inspection, and it is FEMA compliant. That is a non-issue that has been resolved. In regards to the lawful operation, it is lawfully operating. As Mr. Moore spoke about in their litigation strategy, but also under the 2018 ordinance, which would have been operative at the time that the lawsuit was filed, and under which they are presently operating or grandfathered in because of the litigation, it is lawfully operating as an STR. Now, depending on what the outcome of that litigation is, I want to speak to the fire safety thing, which is the last thing. In regards to the fire safety aspects, I have had a chance to read the complaint that was filed yesterday, and what I will say is that we believe that AP6 is compliant with that because of the means of egress, notably access to the staircases that would have been available for that. And in any event, that's not what those statutes are designed to do. They're designed to be applied to hotels and motels, and if you think about it practically speaking, the reason for that is because in a hotel, the door that you access to leave your room or enter your room doesn't go to a staircase, it doesn't go to any road other than a hallway. And And that is why there needs to be other means in the fire sprinklers in that system. So in any event, it's a non-issue in terms of the fire code. But more importantly, and for practically speaking, and I understand that I'm not going to convince anyone else in the audience about the powers of my persuasion that I'm right about these things. I know it's an emotional topic, but just speaking legally, some expertise in this and trying to speak to you all, the decision makers here, is that if the settlement goes through, AP6 still has to go through the application process. And as part of that, as is contemplated by the ordinance, there would be checks that they would have to go through and make sure that they're compliant with. They have every intention to do that. So with that, I hope that that helps you understand and appreciate a little bit better the position of AP6 in terms of the Byrne-Harris claim. I'm sure I'll be back up here to talk about the ordinance here in a little while. Thank you guys for listening. I appreciate it.
Thank you. Would anyone else like to speak tonight? Good evening.
Good evening. Tom Pianco at 540 20th Avenue South. Lived here about 10 years. I have a question, and it's all due respect, but if we settle and have a settlement with this one property, won't that open up additional settlements because we settled with this one property? And I think we really need some sound advice on the impact of acquiescing to one single property. The other question I have is, if they're challenging the ordinance that we have put in place here and from a law, doesn't that open up the whole rules and law that we've already put in place here? So those two things, but I think the first one about opening up continued lawsuits, where's it end? And I would third like to suggest that the city hire a third-party legal counsel to give us advice, because this has huge impact. This one decision potentially has huge impact on not only the community and the culture here, but also the financial impact. And it just, with all due respect, it's like getting a second opinion for a diagnosis, a cancer diagnosis. This is big, this is important, it means a lot to the community, and the city should hire a third-party advisor in this matter. Thank you.
Hi, Kelly.
Hey.
On the microphone's up here. Kelly Watt, 431 Harbor Drive South. I do have concerns about the precedent the Byrne-Harris settlement might create. I do think it would cause others, maybe not the 6 or 7 or 8 that are already suing us, but the ones that aren't suing us yet, I think it will encourage additional lawsuits. And I'm concerned that Indian Rocks Beach might get the reputation of being easy to push around and to intimidate and to make decisions that may not be the best for the community. I understand there's financial considerations. Those are real. I think there's different ways to address that concern than to capitulate and give in to demands that don't seem to be reasonable. My question would be, and I don't know the answer to this, is there a way to table Agenda 6A item? Can we not answer this tonight and revisit this at another time when you have more information? Thank you.
Thank you. Anyone else? Good evening.
Rhonda Smallwood, 439 Harbor Drive North. Rhonda Smallwood, 439 Harbor Drive North. I have a question. So we've made these laws. He doesn't like the laws. Is he not free to sell his house and move somewhere else? Like, if he doesn't like operating under the rules that you've made, then I think that's an option. Like, he doesn't have to be in Indian Rocks Beach. And, because we already have a lot of STRs. And we're just encouraging more bad behaviors. Thank you.
Hi, Patty Katz, 124 13th Avenue, Indian Rocks Beach. Old. So my comment is regarding, we are a vacation town. We are. We have a public beach and a commercial area where the public is able to go and enjoy our town. We're also a residential community where we live and raise our families and would love to have peace and live in the place where we came to many, many years ago with what we thought was going to be a neighborhood and not a vacation town. There were vacationers on our beaches. There weren't this amount in our neighborhoods. Where are our rights as residents? We want to live peacefully. We don't want strange men walking down our neighborhood or groups of people walking down our neighborhood, pointing at our houses and bringing their dogs that they don't pick up after. It's out of hand. It's out of control. I don't mind Airbnbs. I don't mind short-term rentals. But what is wrong with the measures that we put into place? What is so unreasonable? What about our infrastructure, where through these hurricanes, we had our sewers, we were dredging up in sewer and feces. We're not prepared for 14 people flushing toilets a day in Indian Rocks Beach. The infrastructure simply won't allow it. And this will set a precedent to get other people to start suing. I don't notice this in any other community where they are challenging. I think we're a pushover. And look, we have an attorney that gives you advice. I'm all for getting another opinion. Because it seems to me that we are just saying, well, it's going to cost us a lot of money. Let's go forward. Let's give in to anybody that wants to challenge what we want as a community. Furthermore, we spoke at the last meeting. The community said, we don't want these. We want to go through with lawsuits that challenge our rights as a community. And that's all I have to say for now.
Good evening. Good evening. Laura West, 486 Harbor Drive South. I've really been thinking about this STR, as all of us have, and what I'm really concerned about is what's going to happen when these STRs just continue to move in and move in and move in and move in, and there is no residence or permanent residential properties anymore because people are sick of living next door to a short-term rental and they move out. And then when they try to sell their home, the only ones that are interested in purchasing their home is an STR. And especially with these bigger homes, and I do live near several that are the larger homes, and it really drove the prices up, when they first started coming in and were allowed to purchase these homes for, commercial reasons. And it's awful, I live in a ranch, and if I were to try and sell my home, and I'm really concerned, honestly, because I don't want to sell to a short-term rental company, but how am I going to know who is buying my house? Am I going to say, I'm not going to sell because you're going to rent my home? I mean, I would prefer to go back to monthly rentals, which I understand when we purchased our home in 2011, that's what was allowed here. We're either monthly or 3 month. I've heard a couple of different, you know, whatever. I think it was a month, right? Isn't that what it was in 2011 until it changed? And I really have to tell you, if I had known that there were going to be short-term rentals in this community, I wouldn't have bought my house. I wouldn't have. I would have gone to Tennessee. I mean, this is where I wanted to retire. And I bought not knowing that STRs were going to be allowed. I bought in end of June 2011, I think in July it took effect. And I'm like, oh crap, you know? And here we are today. So from my perspective, I would like to go backwards. I'd like to make them even stricter. You know, I don't think we owe these companies anything. I mean, this is a residential community, as someone else pointed out. There's plenty of places to rent up and down the beach. I have a rental property in Indian Shores on the beach. You know, there's places, they don't have to come into the neighborhoods. It's all greed. It is all greed. And I'm a capitalist, okay? I appreciate, you know, and I love this country for the freedoms we have and the opportunities we have to make money. But it just, at some point, it just has to be what's right.
I'm sorry, you're 3 minutes up.
I'm sorry?
3 minutes.
Oh, sorry. Thank you. Thank you.
Hey, Diane.
Before I speak, can we address both the Harris and the next thing, or is it just one?
The question posed was, before she speaks, can she address this and the next agenda item? We would prefer, for purposes of the meeting, that you first address just this item. You'll have an opportunity to come up and speak on the ordinance.
That was my question.
Is this the right one?
Yeah.
Okay. So a couple things. I've been following this house for a while. It seems to be a very bad player, like the bully, and now the bully's going to get their way if they get this, which just seems wrong. But also, as someone who uses Airbnb a lot and someone who also rents my place when I'm not there, I don't understand the big financial impact between 12 people and 14 people financially. Like, it's just not that much of a difference. When you go to rent places, first of all, they don't even charge extra for extra people. So I know that you base your price on occupancy, of course, but at some point, it's a gray area. So I don't really get it. And if, as Kelly says, they're actually advertising 14 people, which means they have the potential to get 14 people, whether it's legal or not, how are they losing money? Because they already have 14 people. So it just seems to me like it's more of a show of bulliness and strength. They've been a bad actor. They've broken different laws. You yourself were saying you had to do the FEMA thing. I remember in court, I think I saw that in the magistrate. So I just feel like I like giving people variances when they deserve it. But in this case, it just seems like the wrong thing to do. Thanks.
Thanks, Diane.
I have no voice, so I'll try. Beth McMullen, 481 Harbor Drive South. And I'm sacrificing my voice to come up here and talk to Al. The house across the street from us is one of the large houses. It has been sold, and there's a new owner. I came up here at least 3 times to tell y'all it's being advertised to house 18 people on Beaches US website. Nothing got done. The owner came up to me the other day before Christmas and introduced herself to me. I mentioned to her, she said that, same story, one day we're gonna live here. So she told me that they aren't gonna have parties, they're very strict about who's gonna rent it. And I mentioned to her, well, you're advertising for 18 people. And she said, oh no, it should be 14. I said, in the first line it says 18 people. She says, well, I'll have that corrected, it's supposed to be 14. I said, however, you are a second owner. You do not fall under the grandfathering in. You fall under the cloak of the new ordinance, and that is 10. She told me, oh no, the city has assured us it's 14. I have the paperwork. I'll show it to you. She has not shown it to me. I do have her phone number. But I can't understand how she would have that thought and how that information got to her when clearly she is not grandfathered in. She is under the cloak of the new ordinance. It's 10. And why would she tell me that? And why does this say 14 on Beaches US? We are setting a precedence. And this is an example of what that precedence will be. If we allow this to go to 14 on 20th Avenue, what do you think this woman will do when she finds that out? First of all, it should never have been 14, it's 10.
Thank you, Beth. Anyone else? No other public comment? All right, I'm closing the public comment on the Bert Harris claim.
Madam Mayor, before the commission discusses, may I address some of the points raised for your benefit? One of the consistent comments was the need for an alternative legal opinion. I take no umbrage with that. That's, as you said, you folks are free to suggest what you need or believe your community needs. However, that said, the city is represented by a separate law firm, Henderson Franklin, Fort Myers, through your insurance company. Your litigation counsel is Carlos Kelly. For those of you who do look at the dockets, my name is not on the docket. Carlos Kelly's is on the docket. That is your lawyer in litigation. Carlos is not here tonight for the sole reason of trying to manage resources, first of all, as it relates to litigation. Second, because tonight's discourse is largely a policy-based discourse, which falls here, but this commission has been briefed directly by Mr. Kelly. He was here just last month and met with the commission as contemplated in the Florida statutes in 286, sub 11, I believe sub 8, for executive sessions. You do have another attorney. This is not just Randy's suggestion, in as much as that's been the suggestion. As it relates to precedent, I understand that that's a natural, logical conclusion to draw. However, when it comes to Bert Harris claims, they are very fact-specific. And as it came to discussing this with the commission and upon receipt from opposing counsel, there was much discussion about the specifics of this property. Not every property will be able to make this argument for a variety of factors, and again, I'm not going to lay out the roadmap. But if we adopt the other ordinance suggested tonight, or stick with the ordinance that's on the books, there are important timing and other considerations that will go into anybody's ability to make that claim. There are also statutory mechanisms within the Harris Act in terms of required notices that may very well bring more claims if we chose to close those windows. And again, I'm not going to go into all the particulars, but you can look in the statute. It provides notice requirements. One Harris Act does not necessarily mean you will receive several or any others. That said, there was a representation made that as it relates to precedent, we don't see this anywhere else. I defended a community that received nearly 40 Harris Act claims, nearly 24 to 30 of which were in litigation, all over their short-term rental ordinance. Similar claims have been presented on the East Coast, in Flagler County and elsewhere, in South Florida. There is, both as it relates to Harris Act claims and as it relates to short-term rental ordinance challenges, while not every community that has an ordinance gets sued, we are not the only community by a long shot. And frankly, I made it very clear to this commission when this was adopted that litigation was a likely possibility based on the shareholders in this process, the feedback this received, the interest in this community. There are other communities in Pinellas County that have adopted similar and perhaps more stringent restrictions, and they haven't been legally challenged. But nothing's a problem until somebody makes it one. And once you have the problem, we don't have the luxury of ignoring it, we have to address it. And as much commission as it was suggested to you that you table this discussion or consider tabling it, I would like to remind you of my obligation to provide a response to the litigants in the next 2 weeks. And I would strongly counsel against you leaving this open-ended tonight. As we look at the landscape, it's a tempting policy to fall back to. If you don't like it, leave. That rarely makes for policy that balances constitutional considerations, which we as a local government must. For those of you who are unfamiliar with me and my approach, nice to meet you. The human element of this is not lost on me. For those of you who have been to prior hearings, you've heard me say, I know that some of you have lived in this community 40 and 50 years. You grew up on your grandfather's lap fishing in the Intracoastal or going on the beaches in high school, and you hoped to enjoy the same kind of lifestyle that your parents enjoyed and that you enjoyed as a child growing here. For others of you, you toiled away in Pittsburgh, Michigan, New York, Ohio, and wherever else with hopes of your sunny retirement in paradise. And you hoped to be on a quiet cul-de-sac in your golden years. And you've earned that and worked for that. I am not suggesting that this community needs to embrace and love short-term rentals. However, based on the legal landscape, we are unable to prohibit them at this phase. For those wishing to turn the clock back, we cannot. We cannot go back for legal reasons. And if this much attention is paid here, I encourage all of you to bring this tenfold to your legislators, because that's where those decisions are really being made. So, and we are, again, we cannot reject reality, we must adapt to it. So, what I say to that is, as we've discussed these issues and it's evolved, most especially since late 2022, when these work sessions first started that led to the 2023 ordinance, one of the points that's been raised is people providing an update on how many properties have been purchased. But owing to the Constitution and owing to our capitalist system, there is nothing that these 5 people can do to stop private money from buying private property with willing participants in an economic transaction. So, and we've seen this with some of the most vocal opponents to these. When you go to sell your homes, are you selling to Jack and Diane doing the best that they can with an FHA loan? Or are you selling to somebody who's going to allow you to maximize your return on your own investment? And I don't say that as an indictment, it's just the reality of the challenge of this process. So we can't do anything that will stop somebody purchasing property, and especially as it concerns the recent developments of Helene and Milton. Whether we desire it, whether we enjoy it, whether we hate it with every fiber of our being, this community will be rebuilt. People are going to have to use financial resources to do that. And we, the commission, cannot decide who gets to buy 123 Gulf Boulevard. And I'm just making up a property name, this isn't, if you own 123 Gulf Boulevard, I'm sorry, true. So with that said, commissioners, you've been presented with a Burt Harris Act claim in the amount of $2.65 million. Can this claim be defended? Yes. Any claim can. However, I've been asked to present you, as the statute requires, to either respond by saying, go ahead, bring the claim, no changes to our ordinances, or to say the temporal, financial, and other costs associated with this as it relates to the 2 occupants, you folks have to make the policy decision. I think there's something that warrants addressing, both as it relates to this claim and the next ordinance. I was contemplating waiting until we were at the next ordinance, but I think it warrants stating now. When we met in August on the last ordinance, we met, I forget the precise day, but I want to say it was August 27th. When we met, that was before September 26th. I was thinking 28th for a moment because of Ian, forgive me, that's one in my life. It's September 26th, and then again on October 9th. Incidentally, my anniversary. It was a lovely evening. Had a sleepover with my in-laws. So, the decision you made then, one of the points raised was, we have reserves. Fight this. Looking at your 2024-2025 budget as adopted in October, or before October, you have a millage rate of 1.73%. The forecasted general fund expenses was 4.8 million, I'll round it to 4.9. Your unassigned reserves, so your just general reserves, was approximately 5.4 million, which was 111% of your general fund expenditures, which seems Dan might not be in the room anymore, but great job for your finance director. And your 5-year capital plan reserves was 1.1 million. That's money allocated specifically. It's not free for any use, if you will. This community incurred more than $3 million in expenditures for debris removal.
Just being reimbursed at 100%.
Yeah. So this community incurred more than $3 million in debris removal costs. You have an excess, as I understand it, of $3 million in insurance claims, of which at this point you've not received any funds in response. And Mr. Manager, if I misstate anything, please let me know. We anticipate there may be FEMA funds. We've done everything we can to maximize any potential reimbursement, as your city has historically done. There's been fires in properties, we've sought grant monies, and those monies may come. Those monies are not here today, but FEMA money may come. Is it accurate to say that we are still awaiting FEMA funds from storms 2 years ago, Greg? No? We received those funds, thank you. So those funds may be forthcoming. I don't know. The federal government is changing administrations. There's been statements of austerity measures, and what's happening in California is happening in California. I don't know. Those funds may come. We can't tell you the timing of it. And the same with the insurance claims. And I'm not suggesting you'll be bankrupt tomorrow. I know that's sort of a narrative, but I do want to make clear the added fiscal challenges that the community is facing. You're not sitting on the same nest egg you were when we discussed this last. And again, that's not offered to militate a result. It's offered to make sure you, the commissioners, have all the information you need to make whatever decision you make. So with that, if you, the commission, have any questions for me, I'm happy to answer them. Otherwise, I defer to you in your discussion of item 6A, an offer of an additional 2 residents, or 2 overnight occupants at the property at 455 20th in complete resolution of their Bert Harris Act claim.
Thank you, Randy. I'd like to open up this discussion on the Bert Harris claim and find out what your response is, Judy.
A couple of hypotheticals I want to run by you. So, I don't think. There we go. All right. So, it seems to me that what happens with this first one is sort of dependent on the next one, isn't it? Not dependent on, but would be influenced by what happens on the next one.
Perhaps the inverse, this one informs how the next one, if the next one resolves. And to take it out of all these pronouns without antecedents, this is, if you have 2 trains on a track towards Settlement Station, this one arrives first, right? We get your guidance on this. If this is approved and accepted and we execute the release, and if the ordinance is passed, which again, we're not there yet, but if the ordinance passes, and for those of you who are unfamiliar with the ordinance process, if there's a favorable vote this evening, it goes to a second hearing. It's not all or nothing tonight. But yes, this is a condition of global settlement.
This is a condition of global settlement.
Correct. If you are seeking to resolve all 7 pending claims,
this is part of
this is part of that.
This is not separate.
No, sir.
Okay. So you don't get one without the other.
No, but let's say if you did, just again, dealing in the hypothetical, I owe it to you to give you the full landscape. If you did not approve this at this stage, we would still consider the ordinance, and if you did amend the ordinance, that may narrow claims, but if you're trying to, if the idea of settlement is, as I said, certainty and control, there's still great uncertainty as to what happens with at least 6 of the 7 claims, and the 7th I would believe to be resolved based on my understandings to this point, but again, that depends on what you do with the next one too, and how you do it. So if the goal is, if the inquiry is, Randy, what is the settlement framework? The settlement framework is you approve this for this one property, you change the ordinance as proposed. If you approve both measures, then all 7 claims are dismissed with prejudice, and there are no claims pending going forward.
That brings up another interesting matter, actually. Let's say this continues to go through the legal process, and we go through discovery and all of that, and it goes to trial. Let's say we lose. What happens to the ordinance then?
2 separate questions. I'll try to answer them in succession, because you're saying if we go through the whole litigation process, as it relates to the AP6 litigant, we would be litigating the validity, the challenges to the validity of the ordinance, as well as their Burke-Harris claim, right? The Burke-Harris claim doesn't go away, and if anybody's holding out hope that some random event will happen and the litigants will all walk away, as a litigator, I can tell you that's not happening. In for a penny, in for a pound at this point. So if we don't settle the Burke-Harris claim, then we litigate that, and if we don't, and if you lose on a Burke-Harris claim, there is exposure to attorney's fees. So if the city were to lose, and I want to be clear, that's not a certain fate. And I'm not suggesting we can't raise defenses. I'm just telling you I'm not a soothsayer. I don't know what will happen. I can't predict the future. Burke-Harris claims are admittedly rarely successful when tried. That process, however, is a lengthy and challenging one. And as you've been advised, may require the retention of experts and expenses that go perhaps beyond certain resources you have available for that purpose. So we would try that, and then if we tried the challenges to the ordinance, assuming, again, that the complaint remains as it is, because they can amend the complaint, but if the complaint remains as it is, depending on the claims in certain cases, there may also be exposure to attorney's fees because they presented 1983 claims, which are civil rights action claims. So there is potential exposure, and that's legal lingo for, hey, could happen, potential exposure to attorney's fees were we not to prevail on either the Burke-Harris claim or the challenges to the ordinance, depending on the claims that they were to prevail on.
But I'm not sure that answered your question.
I think it's because we have to look at two different things going on simultaneously.
I understood the question to be what happens if we lose. As it relates to the ordinance, it depends on how, quote unquote, how we lose. There have been various challenges interposed to the ordinance. Some are violations of the First Amendment for mandatory speech. Some are due process claims. Some are preemption based on the code enforcement statute in 509032. Again, we have very good arguments against them. I'm not saying we don't, and I'm not saying we're willing to raise them. However, I don't know if a judgment will resolve in our favor on all of them. Some of them, none of them. And so what happens to our ordinance depends on what the judgment looks like. And so there's so many permutations to what that can be that I can't tell you this is what happens. They invalidate the ordinance writ large. I don't know, and frankly, based on the direction that the middle district has been going in terms of clearing backlog docket from COVID and otherwise, and based on the process to this point, I'm not fully convinced we'll not be sent back to mediation or perhaps arbitration before a magistrate, or mediation before a magistrate, or some kind of arbitration. I've been seeing that happen in other middle district cases involving other communities in Pinellas County and otherwise. So I'm trying to bring all those factors in, and just again to your question of what happens next, I could have never told you when we ended the August 27th meeting that within 4 days we'd be ordered back to mediation. That's how challenging it is to predict what's going to happen.
you have anything else, Jude? Okay. Vice Mayor? Okay.
Vice Mayor said no, nothing at this moment.
I'm gonna wait until the end. Well, at this point, Randy.
It's for you folks to discuss. This is that time as it relates to item 6A.
And John Bigelow, what do you have to add?
Well, what I have to add is the company that bought that property to make it a business and try to make some money, they should have done a much better job of their due diligence, which it's obvious they did. So they're expecting the city of Indian Rocks Beach to come up with $2.5 million to bail them out of a bad investment. That's my opinion about 86 on 20th, and I really don't have anything else more to say about it.
I don't think that's really how this thing's working though.
I can speak to that a little bit. The question of a Bert Harris claim is, it is a very unique creature of state statute. If we could turn off the mics that aren't in use. It's a very unique creature of state statute. The damages claimed are not actually business damages. The claim is to devaluing the property, diminishing the value of the structure, property itself. When we talk in the law about property rights, it's the analogy you're given in law school is property rights are a bundle of sticks, and each of those sticks has value. And so the claim is here as best as understood as the claim made, whether valid or not, is that the government has taken one of those sticks, or some of those sticks, and the value of those sticks is, as they claim here, $2.5 million. And so that's the claim that you would be defending against. And again, my recommendation that you consider this settlement, and your litigation counsel's recommendation that you consider this settlement, is not to say, oh yeah, they got that nailed down, Pat, that's definitely what will happen. It's, we have an obligation under the statute to come to you, say, here's your claim, here's your potential risks, your potential temporal and financial costs, what do you want to do about this? And one proposed solution is giving 2 occupants a single property in settlement of that claim. Can somebody else make Bert Harris claims? They can. They get more challenging as time goes on, and I know the defense is. I can never promise you tomorrow is not promised. We can prevail in litigation and other people can still sue us on other theories of liability that have not yet been raised. We can go through this whole process and the legislature in all their wisdom comes up with some wonderful whiz-bang solution yet again that we have to adapt to by May of, likely July 1, 2025. So any number of things. We are not fully in control of this process in the court system or otherwise. I'm suggesting to you this is one way, if you so wish, to resolve it with control here.
It's 4 occupants.
Thank you. It's 4 occupants over the current ordinance, and it would be 2 more occupants based on the ordinance that's proposed this evening. And as I'm dealing in all of these things, sometimes those get jumbled in my head. Again, this is not a foregone conclusion. I'm just trying to reconcile a lot of data in a brain that's working overtime.
So, but we need to vote on this portion.
I'm seeking your authorization to send the correspondence as drafted based on my impression of the litigation, discussions had in executive session and otherwise. But again, this is now for you to tell me what you wish to do.
Point of order. Are we able to open up for comments since additional
No,
information has been? But you've spoken a lot about the forthcoming potential revenue that's going to be taken from the city, and I feel it has definitely provided us with additional information that we would like to speak on.
I defer to your mayor in terms of if they wish to reopen public comment. That is entirely a decision of the parliamentarian. Point of order is.
Robert's rules.
Ma'am, I'm familiar with Robert's rules. I educate public officials on it. I know what you're going with. It's just that your point of order usually points to a rule of procedure. There's not one for the mechanism you're describing. However, Madam Mayor, it remains in your discretion whether you wish to open it.
I'd kind of like to discuss it with my commission first before we open it back up. Because there's a lot to decide here. And it's true, we can't put the genie back in the bottle. We can't take COVID away when we got flooded with short-term rentals. We can't take Helene away. That obviously is going to change the landscape of this little island for a long time. And, you know, how can we mitigate excessive lawsuits for the future?
Or commercial, what's residential?
I
I'm
can't.
wondering if there's any value to maybe having, and I know that, to maybe moving to the next. I'm wondering if there's any value to putting this, to moving this first item to second, because the second item is the one that's really, I think, it determines everything else.
There's no clue.
That's just, I don't know procedurally how that, if that's off base or not.
Procedurally.
Residential, now shut up.
Trying, man.
I'm going to defer to your conversation. I don't, if the Vice Mayor's question is, can we change the order of the agenda at this stage and go to the second one? If it's the desire of this commission to do so, it's your meeting. We've had public comment, you can have it again if you so desire that as well. It's your meeting, just tell me what you want.
All you have to do is make a motion.
Thank you, ma'am.
I don't know that helps this proceeding, since we've already been deep into the Burke Harris claim. We've even heard from AP6.
I guess the reason why it may be relevant is because if we're gonna say, no, we're not gonna do this, you know, you can't have 14, and then we're going to go back and look at this other thing, it's different than if we say you can have 14 and then go back and look at this other thing. I just think that the result of the one is going to inform the result of the other. But I think more consideration, okay, I guess. You know what I mean.
I do know what you mean. Now, does anybody else have any comment they'd like to make before I ask for a motion?
I just want to say that I feel like all the questions that everybody sent, all the emails in about, I feel like they were mostly answered. I had the same questions. So I am listening and I heard all the answers and I understand them.
Vice Chair?
I don't have any additional questions. I do believe that I would like to hear, give the opportunity for additional.
Okay. All right, well then, at this time, I'll open it up again for public comment on the Burke Harris plan. Who would like to speak?
Can I speak again?
Beth McMullen, 481 Harbor Drive South. I just want to talk about adapting vacation. I don't know where anybody gets the impression that we don't realize that we live in a vacation area. We do. We've all lived here. We know what Gulf Boulevard is about. We know there's places for people to stay. And when you say we're not adapting, I find that personally insulting because we have adapted. We have had no choice but to adapt. We have had to live with the problems that have come with these short-term rentals. They came in a flood to us, and we've had to live with the noise, the trash, all the parties, all of that. We've had to do it. So we put together an ordinance, okay, because we know that this is a problem. This community wants a strong ordinance, one we worked so hard to put together. We don't want it dummied down. We accept that we have to live with these. We accept that they're coming into our neighborhoods probably in a flood now, even more, literally in a flood, because of the hurricanes. We understand that. We know that there's nothing we can do about it because the state won't allow it. If there are people here that want to take it up a little further and see if they can rid the neighborhoods of it, That will have to be done at the state level. We understand that. It does not affect you all if that's what people want to do. What you need to do is support your residents, this community, to have some semblance of peace in our neighborhoods. That's all we're asking. What is so wrong with this ordinance? Why are these people so afraid of them? I don't understand it. All we're asking is for you all to work with us so that we can live peacefully in our neighborhoods, so that there's not going to be arguments. And it has worked. Once this ordinance was passed, I've lived here 32 years, okay, and I know what I'm talking about, and all these other people do too. It worked. Things were settling down. And then thumb sucking happened. Oh my gosh, you can't tell me what to do with my house. And it is a house in our home, you don't live there. And so these lawsuits came about. We're not asking for too much. We're asking for peace. We're asking for you to have the people that come in here and stay in this neighborhood to have some type of normal reaction or interaction with the people that they're living around, the residents. So I don't understand why it is concerning so badly to all these people that have filed this lawsuit. Work with us. That's what we're asking. Okay? We're not unreasonable. The things we're asking is not unreasonable.
Ms. McMillan, I'm sorry, it's 3 minutes.
Hi, I'm Carol Stampy, 434 Harbor Drive North. I'd like to speak a little bit about the economic impact of this. We know that they are threatening us with a $2.65 million potential lawsuit. Well, where are we, I don't know, Randy talked about the different, sticks that are in this bundle, and I'm not sure I quite understand that, but if they're basing it on their economic, what they have lost, or the value of their house, are they looking at the supply and demand for short-term rentals? As FEMA comes in and says, no, you can't rebuild, how many more places are going to turn into short-term rentals? Because that's who can come in and raise the house. A lot of people are going to be kicked out of the community because they can't afford to raise their houses up. They're threatening us with that, but I don't, it is not for our city to guarantee their income for a residential thing. There's businesses that come and go all the time, and it's not for our city to, guarantee their income. Thank you.
Lisa Cicero, 448 Harbor Drive South. To me, this is very simple. This property is still advertising for 14. They don't have an economic loss. They have not had an economic impact. The Bert Harris lawsuit, you have to prove you've had an economic loss. They're advertising for 14. They haven't stopped advertising for 14. They're not being restricted to 10. Where is the economic loss? I don't think, as our city attorney has said, it's not easy to prove Bert Harris losses. I don't think this property has any losses yet. If they're not getting the same money they got in 2023, 2024, it might be because conditions have changed in Indian Rocks Beach, and because big families are not, and big corporate groups are not renting as much because COVID has subsided. So that's my take.
Good evening, Matt Kinez, 111 Canal. I don't know that it's been discussed, but what are the financial ramifications of moving forward in terms of attorney's fees, if there's depositions, like what are we looking at as a financial burden to move this lawsuit forward? I think we should hear at least some of that. Yeah, in terms of that, I mean, it's 14 residents in a very large home. I mean, I bought my property prior to 2018 to have it as a vacation home for my family, as well as help it pay for itself by utilizing short-term rentals, and that's what I still do today. So I mean, in terms of not being part of this community, I'm not a big corporation. I have myself, my wife, my 2 kids. We enjoy this community very much. We also run a business to rent it out to help pay for it. It's what we utilize. These restrictions have big impacts on us as a family. When we have a home that can house people, we also actively manage it to where we don't have big parties. We've never had a complaint from any of our neighbors. And yeah, I mean, in terms of the economic impact, we had $5.4 million in reserves for the city. Our taxes help pay for that too. To see all this money get wasted on lawsuits is insane to me.
Is it on? Oh, okay. I was actually going to make comments for the next part, but
It's not time yet.
it's not on?
No, it's not time yet.
No.
We're still talking about the Bert Harris plan.
Oh, no, this is actually more relevant to financial impact.
Okay.
Can you just say your name and address?
Oh, Carol Britz, 466 20th Avenue, Indian Rocks Beach. While some of the investors are pointing their fingers at our regulations as reasons for change in the demand of units, making it harder for them, I think it's important to consider historical data and short-term rental trends. A lot of the growth in short-term rentals was fueled by demand and low interest rates. By 2021, the short-term rental market was on fire. People were traveling again after COVID. Many opted to avoid crowds and stay at STR. The housing prices were soaring. Investors continued to buy more and more. This temporary increase also allowed them to invest their nightly rates. Excuse me. June of 2022, the CDC lifted the negative COVID test requirement for re-entry to the U.S., which resulted in a huge increase in the number of U.S. citizens vacationing outside the U.S. 2023, Airbnb and others began publishing articles advising the owners to lower nightly rental rates because the supply was outpacing demand. Sorry, I'm getting nervous. Okay, so while the big corporations like Airbnb continue to see more increases in supply, the individual investors begin to see slowing occupancy rates because of excess supply that began to erode the income and profits generated from each property. 2024 investors continue to see a decrease in demand due to high inflation, excess supply. 2024 also brought Hurricane Helene to our city. Today, while many of the STRs are up and running, we still have full-time residents that are not able to live in their homes and have left the area to find an affordable place to build, or rebuild rather. Along with our city, the majority of our residents have suffered financial loss this year. Many are still in shock, and the majority of the residents are not even aware of this meeting. I think it's very inappropriate to be considering these conversations or making any changes to our regulation at this time. I think it is ridiculous time to give in to this. I think we should be focused on recovery and healing our community and protecting our residents. In closing, I ask you to look at the chart I provided, especially the bottom line, RevPAR, revenue per unit. While the revenue per unit, or annual revenue per unit, increased 21.3%.
Carol, I'm sorry.
You
can take mine. Yeah, you can take mine.
Okay.
I'm sorry, ma'am, can you just further?
Jolene Bircher?
Jolene Bircher, is that your name?
Yes.
And do you yield your 3 minutes? Or?
Yes, I do.
You may continue, ma'am.
In closing, I ask you to look at that chart I provided. When the market was on fire, you notice that the annual revenue per unit increased 21.3%. It fell to a negative 1.7% in 22. And then it fell to a negative 8.3% in 23. The projection at the time of this report was estimating 0.6% in 24. Again, we should not be making modifications to regulations or giving in to ridiculous demands. This This lack of demand for STRs is not unique to IRB. It has nothing to do with any of our regulations. There is no basis for the investor complaints. I say that you stand up to all justified demands and protect us. Thank you.
Lynn Rothman, 929 Harbor House Drive. I really want to say that I commend the commission and Randy, because this is a very difficult decision, and whether this is a good time or not, as Randy explained, by law you have to vote tonight. And in considering how to vote, it doesn't matter whether the owner of the property is being greedy or whether they should leave. They're suing you, and you can't control that. So whichever way you vote tonight, I know you're trying to balance the financial risk to the city. Because if you go through a lawsuit, there is a financial risk. Maybe we'll win, and there won't be. But either way, I commend you. I thank you all for all your consideration, and I will support your decision. Thank you, Lynn.
Go ahead.
Randy Briggs, 466 20th Ave. I have a question about the dollar value of this suit, 2.6, 2.5. Can anyone explain to me how that's determined? This house is about 5 doors away from me, and I think that's pretty close to the value that they paid for it to begin with. So I'm just kind of curious as to how this dollar figure was calculated.
Thank you.
Good evening. My name is Laura Robinson, currently live at 1923 Gulf Boulevard. I used to live at 424 18th Avenue, directly across the cove from your lovely residence there. As much as I enjoyed looking at the beauty of the property, I did not enjoy the noise that came across the cove. I'm not going to say it's one of the, it probably played a role in why I moved. The noise that's come out of that house is we're all familiar with it, right? It's not just the noise, it's crime that comes along with these multi-level, huge occupancy homes. If you look at the police reports that were just included in your agenda, you'll notice a huge decrease in November and December police reports. It's no surprise, right? Nobody's here, there's no crime. We'd like to keep our small little beach community crime-free. We'd like to keep it party house-free. I would encourage you strongly to not settle this. You have taxpayers here that are telling you do not settle with this lawsuit. It is only going to open the floodgates to more. We've all seen how it happens. When one is successful, they all come like little marching ants following. So it will not stop with this. I encourage you to vote against any settlement with this company, and I thank you for the opportunity to speak.
Thank you. Hey, John.
Hello. I just first want to respond to one thing. We've heard this over and over again that there's nothing we can do about it, about what goes on in Indian Rocks Beach with short-term rentals. There is a lot we can do about it, but nobody's bothered to do it. I've given, I don't know how many times I sent things that this commission can do to wage a war in Tallahassee to get what's only right, residential being residential. We can do these things. We can gather with all the other cities that are having problems out there. So I hope this commission, I know it wasn't created by you, but I hope this commission has the will to try to fight back for what we want, which is residential being residential. There are a couple surprises this evening. One is I didn't understand after reading the packet and all that, how the relationship between these two different things are. Randy can correct me if I'm wrong, but it sounds like you've got to pass the first one about the Bert Harris, and then pass the one about gutting our resident things to make these lawsuits go away. That's just not tolerable. Hopefully we'll be able to talk about that later on. But and the other thing that was nice that Randy mentioned was that Bert Harris typically are very hard for them to win. So you ought to keep these things in mind as you're making this decision. I would certainly suggest that you turn this down if there's any chance you're gonna turn down the other one, because otherwise it's moot. So I hope, oh, just one other thing. We get crime reports every month, but they never talk about how much of that crime is due to the transients. Just in our neighborhood, I had a woman come to me in tears the other day. Her two very young, petite girls were out, and one of them was running, and a car comes up behind them, revs its motor, pulls over, tries to get their name, tries to talk to them, drives by them, parks again, so we have to go back, and did this continuously. You know, this is what's happening with these transient lodgings in residential neighborhoods. We're gonna have our kids, you know, carry arms, carry guns, so they can walk next, you know, through the neighborhood. This is just crazy. We ought to require that the police tell us how much of the crime is due to transients and short-term rentals. Thank you for your consideration.
Thank you, Tom.
Patty Katz, 124 13th Avenue. It just occurred to me that you have all these residents investing their time and telling you this is not what we want. We do not want this. All of us. We don't mind short-term rentals. What is wrong with them abiding by the rules? And what could possibly go through anyone's head when your whole community stands before you telling you we don't want this? It's like taking a parental role, saying, oh, we know what's best for you. Well, if somebody's qualified to do that, please let me know, because I'm not seeing it. We don't want this. We want to fight it. You need money? We'll give you money. I can speak for myself. I will put money in that game. We don't want it. So when you're making the decision to gut everything that we've put into place and spent our time from our families and work and everything else that we're doing, we're not getting paid. We have no, you know, we don't get what the Airbnbs get. We don't have any financials involved except for our peace. So when you're making a decision to gut this, make sure that you know you are voting against your community. Thank you.
No more crosstalk, please.
Hello again, Brett Parker on behalf of AP6 Phelpstone Bar, 455 20th Avenue. There have been a few themes that I wanted to address that I think are of interest to the Commission. One of them that I've heard about was, you know, the reason and why is there a Burt Harris claim in the first place, and I think I've also heard about some bad investment strategy or something to that effect. So I want to dissuade of that misconception and just candid factual inaccuracy. So the only reason that we have a Burt Harris claim is because the property was purchased in 2021 when the 2018 ordinance existed, and at that time, with what you would call under the law the investment-backed expectations of the purchaser, were that we could rent the property as we have been. Fast forward to 2023 when this ordinance that we've challenged was enacted, it eviscerated that right, that property right that existed, and that's the basis of it. So when the property was purchased, when the investment was made in 2021, we had the expectation of something that has since changed. The property value is therefore diminished. The next thing that I would say about the diminished value and how the property damage in 2.65 was done, it's statutorily defined under the Burt Harris claim. It's not lost revenue. It's not lost profits. It's the diminished value to the property itself. So that's where you get from the appraisal report that's part of the public record and inside of the thing. In terms of the Burt Harris claims being hard to win, I want to get a misconception there. It depends on how you define win. Win is a relative term. For example, if a win in the eyes of someone from another community would be that this Burt Harris claim never sees the light of day, to some that might be a win, but to apparently most people in this room, it would not. Right? So it depends. It's a relative term. So it depends on how you define win, but most of them settle, and that's what's been proposed to you today. And the last thing is about working together. I mean, I think Mr. Morris said it, and I know Ms. Wine heard this at the mediation from the mediator and from the judge about the mediation process, is that, you know, this is about compromise, and that's what we're here to try and do. We're not going to persuade everybody, we're not going to convince everybody, and we certainly aren't going to be able to make everybody happy. So one outcome, though, however, is that there was a question about that, and this bleeds into the other issue, so I don't want to dwell on it much, but one outcome is there would be no regulation if the cases do not settle and if the court proceeds in a certain path. There would be no regulation on short-term rentals. That is one possible outcome. So just something else to consider. Again, thank you for your time.
Yeah, David Whiteside, 446 Holt Drive North. Just hearing this gentleman's, reason for the challenge, based upon the investor's expectation when they purchased the property. We all had expectations when we purchased our properties 20, 30, 40 years ago, right? The majority of us had the expectation that this was a friendly, local community, not having 6, 8 cars parked on the drive next door to you, not having increased traffic throughout the city, right? We all had expectations of when we purchased this, right? If you vote and allow these changes, all of our expectations, all of our hopes are just down the drain. It's only going to get worse. Randy talks about, yes, we can't stop people from buying properties. We can't say no more investors can buy a property. But if you give in to these votes and you increase the number of people that are allowed to stay in these houses, you're essentially giving them a step forward to continue to buy these. You need to uphold the ordinance, right, as a way of saying, this is where we're at today. We're not going to move forward and allow you to keep buying investments and with the expectation that you can now charge $200 or more because now you can put 14 people in a house rather than 10 people. We have to put a stop to it. We have to respect why we all moved here, our expectations when we purchased. Thank you.
Jennifer Riley, I live at 510 Janice Place. That was my sentiment also, is that your client, you have expectations when you purchased the property. I also had expectations. I am east of Gulf Boulevard. I moved into a residential area, and it was residential at that time, but things changed. We adapt. Ordinances changed, and I had no choice in that. I don't have, we have the ability to sue our city because that changed. We don't have that opportunity. So because your client bought at a certain time and it was a different climate, then ordinances changed. They change all the time. So if that's the expectation and that's the reasoning, it's a really bad reasoning that we're going to allow them to win because their expectations changed. So did ours. So I understand that we do have to adapt, and I think most of the people here understand that we can't stop short term. That's not what we're asking. What we're asking is for us to enforce ordinances where we can all live together, where there's peace and safety in our neighborhood. That's all we're asking. We're not asking to shut them down. We know that's not reasonable. So why can we not enforce what we believe are the right ordinances to get us there? And we have proved that. The last couple of years, I lived, when a short-term rental moved next to me in the first, before COVID, it was horrible. 14 people staying there in 1,200 square foot home. Yes, they were all out back all the time, partying, throwing stuff over our fence. But that was resolved with our ordinances. We were able to enforce what we had put in place. And now with the threat of rolling those back,
gonna go back to that where it's unsafe. We're not gonna be able to live peacefully. And now with the storms, it's even more of a threat because more investors are coming in. I was called 9 times by investors to see if I wanted to sell my house after September 26th. So please, please help us protect what we have left of our neighborhood, of our community. That's all we're asking.
Hi, my name is Tom Wilson, 444 Harbor Drive South. I'm just going to start off by saying I'm really sorry about everybody's losses, and that's being lost in a lot of this. Everybody here has been hit very hard. Council, a lot of people that are selling their houses, and like Jen was just saying, I've got plenty of calls. The vultures come in when they see things happen. You think about Beth, the house that she was talking about, I live directly across the water from that. I could be 2 o'clock in the morning, and everybody knows that lives on the water, noise travels. It travels loud at 2 o'clock in the morning. You can't keep your windows open. Now we've gotten along, these ordinances are minimal. They're minimal ordinances, they're nothing. And yet they want to get rid of them? You know, we're not your client's annuity. You know, there's no guarantee here. That's it. I mean, it's like, you made an investment, think about the people in the community here. I mean, seriously, everybody here has been through a really bad time. Think about the people, not what the investment was. I mean, it's just crazy. On the other hand, if this does go through and we do have to get rid of the ordinances, we actually still have an ordinance that we can fall back on, and it's called, like, you know, peace and dignity, a noise ordinance. We haven't really been doing much with that because we've been trying to get along.
They don't enforce the noise ordinance.
Well, they can enforce it if we keep calling the police. We haven't been doing it because we're trying to get along. Or even driving down Harbor Drive South, down to Harbor Drive, you can have 10 people walking side by side. They won't move. You kind of say, come on, let me go past to get down to where I got to get down there, and they give you a finger. I mean, really, who needs that? So you just laugh and you just go along with it. But it's insulting that we have to be sued over minimal ordinances. And that's really about it. Thank you for your time, and I hope everybody can recover.
That's in the general ordinance now?
At this time, for the benefit of the group, we are still on item 6A concerning the Burt Harris correspondence. That's where we are in the proceedings.
Thank you, everyone. I appreciate your consideration in letting us reopen this. I want to address 2 things.
Could you just state your name?
I'm sorry, Bob Copeland, 447 Trinity Avenue. I want to address 2 things that were brought up. One is the value of this claim. They call them MAI. You know what that initial stands for in the banking business? Made as instructed. I started my legal career in the SNL Crisis Special Assets Department. It's like the statistics. But let me point out to you, somebody just texted me while I was here. The property appraiser value of this property, they want $2.6 million bonus check. A property appraiser on our website says the just market is $3.1 million as of 2024. That's a fact. It's right here. So this gets back to what some people have been saying of this bad investment and the change in economic situation. And you have to prove those damages. Secondly, this is what I call sport litigation. This is exactly what somebody said, a bully. And look at the timing of this Burt Harris and the problems put upon the city. One, the city's a multi-million-dollar monopoly. Their money comes in every year. It will be here. You can borrow it. You have to go back and forth. I've been through this with HOAs and condos. Guess what?
You just assess everybody, which means that the short-term renters have to, property owners are kicking in to pay for themselves, to fight themselves. Secondly, not to discuss my situation personally, I've been in the bar 43 years. Lucky I did what I call financial gladiator and real estate train wrecks. My client base was publicly traded companies, billion-dollar companies on the New York Stock Exchange. I was looking to open a small boutique firm. That's all I represented. Billion-dollar companies. And they would say the same thing. When are they going to stop on this stupid lawsuit? I said, it's for litigation. They're just trying to wear you out. Billion-dollar American stock, New York Stock Exchange companies would ask me that. I said, they're just trying to make, it's sport litigation. So as soon as you make them feel the pain, they will stop. I was called the fixer for a financial institution that's on the New York Stock Exchange. And they would ask me about bills during these financial gladiators. And I would tell them the same thing, and they said, you're right. They're just trying to wear us out and make me report to my boss, and why's it got this high, why's it got that high? So I'm done with my 3 minutes. Thank you very much. You understand what I was getting at on value and litigation. Thank you, everybody, for everything.
Hi there, Christy Smith of 484 Harbor Drive North. I just wanted to point out that the home that we are being sued by on behalf of, the extra 4 people that they are wanting modification of this ordinance for are being housed in an illegally coded 4-person bunk room on the first floor. That isn't legal. So this is what they're fighting us over, is to house 4 people in a room that they're not legally allowed to be housed with.
Anyone else?
My name is Joe Mullin, 461 20th Avenue. And we talked about the Harris law, the act, and value depreciation. Well, and expectations, and those are some of the key words that have stuck with me tonight. Of course, the value of my home, I'm next door to a 5-bedroom bath, and I had issues in the beginning as well. I talked to the owner, we managed to work it out. And, but back to 455, what they do is beyond trying to coexist with the residents. There are tiki boats with bands, with cocktails being served. They have water shuttles going across the cove to bring extra people because of the parking situation. And in some of the literature that I read, they talked about additional sleeping for 2 more people and stretching the interpretation of where these people can sleep. I know many builders, they have to comply with regulations. A bedroom consists of a room, a closet, a door, a window. And I mean, pretty soon, if you can sleep in the bathtub, is that an interpretation of habitable space? Can they sleep in a sleeping bag and hang themselves up in a closet? I mean, where does it end? So, I mean, I don't mean to make light of it, but it's almost insulting to think we're arguing about 2 or 4 more people. And expectations, no. I've been here since 1974. I brought my parents down here. I bought down here. I retired, I tore a house down and built an upper story following regulations and all the laws. My husband was having a triple bypass. The township made me not occupy my house until I put a $1,500 deposit so that the landscaping would be done, when I don't think they really thought I wouldn't finish landscaping, but my husband is in the hospital. Anyway, But back to the point, I mean, there are tiki boats, they have weddings, showers, they have balloons and advertisement on the front lawn. It's not residential, it's commercial. So my value's going down, my expectations. I didn't do a Harris Act claim because these people moved in and did this to my neighborhood. We're all trying to coexist, and we were coexisting with these ordinances. We are already compromising. Where'd the attorney go?
I'm so sorry.
We are already compromising. Okay. Expectations, compromise, we're already doing it. And I hope you realize we do not want you to roll over. I'll contribute and pay whatever to this community. Thank you.
Hi, good evening, I'm back. Laura Robinson, 1923 Gulf Boulevard. This is the first meeting I've attended, and I want to thank you again for the opportunity to speak. One thing I've noticed is that everyone that's come up here has basically told you they are not in favor of this at all. Okay? Your community is speaking to you. I was a union rep. I had to make tough decisions and do things I didn't like. It wasn't in my personal benefit, but it was what my membership wanted, so that's what I did. It's tough. The seat that you're in, I don't envy you. I've sat in it. I know you understand what I'm trying to say. My big consensus of everything that I've seen here is the community has told you no. What I would encourage you to think about right now is we've just gone through this tragic storm season, and the for sale signs are everywhere. You have an opportunity right now to set the standard of how this community is going to move forward when it comes to STRs. And I know we're going to get into a lot of that later, but if you don't set the standard now with this specific house, you are going to open the floodgates. And you talk about a $2.5 million litigation now, you can add that to every 3-story, because they're gonna go, oh, well, that's what they got. That's what I should get too, right? I'm a 3-story, I sleep 14 people, I should get the same amount of money. It's going to become a huge financial deficit for this community if you do not set the standard now and put your foot down and say, this is what we are. We are IRB strong. How many times have we seen that on our Facebook pages and in our community over the last 3 months? We have the ability now to set the precedent for the decades in the future. We accept Airbnbs. We know that they're part of our community now, but we have an ability, and I know we're gonna get into this later, to regulate and enforce those regulations. But right now, this needs to stop. It's frivolous. You can label it however you want, as a bully or somebody who's looking for a cash grab. It's unwarranted and unnecessary, and I encourage you, as every person that stood up here before me, I haven't heard one person that stood on your behalf that has said, yes, we support this. No, everyone says no. So please listen to your constituents and do the right thing for our community. That's the reason you guys are on those positions and in those chairs, is to make the decisions on behalf of your constituents. It may not be something that you personally agree with, but that's what we elect you to do. Thank you.
Jorge Glacino, 124 13th Avenue. Just a simple comment with city attorney comments afterward. I noticed that it seems that we're only addressing the negative, what happens if we lose. I ask that you also ponder the positive, what happens if we win. Right, we gotta look at both sides of the issue without steering, without trying to maybe forward an agenda. Let's look at both sides of the coin, because we don't know what could happen. So let's consider everything and be fair. Thank you.
Does anyone else have a comment? Well, I think we're back to discussion within the commission. Land.
I'm sorry, I'm slow.
Okay.
Land Bond, 301 Harbor Drive in Eagle Rocks Beach. I would say I feel sorry for you. I do feel for you because I was actually in that seat when we drafted this ordinance. We spent time with our community. We worked with our community. We developed this. We went through a hurricane. Our community was there for us. I didn't see any of these guys helping our neighbors. I didn't see anything of the short-term rentals doing that. But I did see people walking down the street that were renting short-term rentals, while I have a next-door neighbor that's living in a house with one light socket and a portable heater. And I don't see anything being done as far as taking care of the Airbnbs that are currently running, that have started developing all that. Randy has said a lot. He's done a great job of scaring you to a point. Really, it's very easy. You just vote to what the constituents want. And then you can hold your head up high as you go throughout Indian Rocks Beach and all of the places that the citizens will see you through the course of the year.
Matthew Barraclough, 211 11th Avenue. I just want to thank Lan Bonner for not really telling the truth about the work that I do. I met with Lan right before the hurricanes, talked about what we could do to come together with a solution. He probably won't talk about that. But I met with Lan, I met with the commission privately. I've been here 8 times in the last year. Now, I've given you your time, Patty. Be quiet up front. I've given you your time.
Sir, just please make your comment.
My comment tonight is, I've done a tremendous amount of help with my neighbors. Lan doesn't think that. I provided housing for a family to keep their child in school.
It's your opportunity to make a comment.
Interesting, because you didn't, sir. You did not do that.
Yes, we did.
No, you did not.
Yes, we did.
What we're talking tonight about is you're ridiculing. You think we're here to criticize people like myself, others individuals who don't think you do anything in this community. Pause, please. Give me my respect me.
Please.
I have given this community time.
Oh, thank you.
It's disappointing that we're here tonight. It's disappointing that people don't recognize that there's a larger community than just these individuals here. There's a lot of people here, there's a lot of value we create. There's a lot of help that people like myself provide. I imagine there's a large majority of people in this room who had friends and family who stayed in a short-term rental after the storm. They provided value. And I think it's disingenuous to think that there's not value being added to this community. As the mayor brought up in the very beginning, this is a vacation community. There's a balance. But when asked with this ordinance, what you're asking about the Bert Harris, you don't understand it. You need to look into it. You're going down a path where you don't want to go down. Thank you.
Don House, 21 Fort Beach Road. I'm 73 years old, and I don't even remember the first time a black kid showed up in my school. None of the constituents wanted that. Segregation was the rule in South Carolina at that time. Nobody wanted integration. But it was the law. And we had black kids in our school. There was nothing we could do about it. It was the law. I think what's happening here is that you are going to have to follow the law. If we're going to fight this as a city, which I don't have a problem with, all these ordinances and all that, you cannot fight it here. I don't care what you think, you cannot fight it here. It's in Tallahassee. And if the city wants to fight that, I'm all for it. I don't care. Just don't hold these people accountable for something they cannot do. If the constituency wants this to happen, you cannot make these guys do it, or the whole city is going to suffer. Fight Tallahassee. Fight Tallahassee. Don't fight these guys. Thank you.
No applause? No applause? What the hell? What the hell? Nobody likes me? Hey, I'm taking drink orders. What do you want?
431 Harbor Drive South. Thank you, Don. I'm just going to disagree with Don's prior statement. This is your job to represent the community. We aren't going to fix this at Tallahassee, but there are some small things at a local level that we can do. And you guys are in the place where you can do it. And I think you want to do it. You're part of the community. You love the community as much as we do. I know you guys are really tired because I couldn't see the expressions on your faces. But you can do this, right? You love this community, and it sounds like the only reason we're making possible different decisions is because of the financial impact. Don't let that be the thing that sways you. That is not enough. We can fix the financial problem. There are a lot of ways to do it. This is not that way. So say no to A, say no to B, and let's go home and have a drink with Dawn. Hey, Jerry.
Hi, Jerry Newton, 438 Harbor Drive North. I thought we were on a pretty good track until the last couple of people. They don't seem to understand what the decision is that we're trying to make here. We're trying to decide whether to give one violator of every rule that we've ever had, even before, that's been a bad actor from day one, and we're trying to reward them because what? Because they say they lost some revenue because what? I lost the point. It just went right over my head. Because their sticks were broken? I don't think. Okay, and then while we're on that topic, 100% agree that the people that live in our community are asking you to say no on the first one and no on the second one. Done deal. This nonsense about having somebody stay with them, yes, of course, we pulled together as a community. And I'm sure some short-term rentals did act as temporary housing for some people that were displaced from their homes. So what? That's not a reason to drop our codes that we developed over years of hashing it out and making everybody agree on some fair regulations, and we're going to throw that all out the window because of some of this nonsense? Thank you, that's all I got to say.
Does anyone else have a comment? I'm closing the public comment on the Harris Act.
At this point, members of the commission, what we'll be looking for is either additional discussion on your part, happy to answer any questions you have, and ultimately some direction as to whether the letter should be sent in its current form. If not in its current form, sufficient direction so that I can comply with my statutory responsibilities to respond to the plaintiff.
The Vice Mayor has some comments she'd like to make.
I would like to clear up the misconception that Matt met with the commission. He may have met with individual members, but I can assure you I have not met with Matt. And it was not with a commission. Just wanted to clear that up.
I would also like to clarify that after Helene, I contacted Matt Barraclaw and I asked him whatever housing any of his people had for our people that immediately became unhoused, could he help us? And he reached out to me multiple times with opportunities for people to move in for way less cost than what it costs to operate those short-term rentals. He did help. He didn't stand by and do nothing. Everybody helped that could help. that wasn't already drowning in what they had to take care of themselves. We were a community that came together. It didn't matter if you were a short-term rental owner or a resident. Everybody helped. And thank you, Matt. I will honor you that I know that you did help. I don't want to stay a divided community. I just don't. As we know, short-term rentals are not going away.
We know that.
Most of the things in the ordinance are solid. And you're not going to change the peaceful community you liked after the last ordinance. It's not going to change that. We have one organization here that's asking for 2 more people in one house.
Stop it.
No.
It's not about.
What?
Folks, this commission has sat here and patiently listened to public comment this whole evening. We've been here since 6 o'clock. It is nearly 9 o'clock. Please allow them to deliberate and discuss.
They were asking for 2 more people. The current ordinance that we mediated asked for 12. From the original 10, we mediated to 12. You know, the judge made us go back into mediation because we couldn't get to a mediation that everybody did agree on. And I have no doubt that if we can't agree tonight, we're going to be back in some sort of mediation or arbitration, as Attorney Moore mentioned. But if we're always...
Mayor, I want to be clear at this stage, because I'm leery of conflating the issues, and we've asked the public to confine their comments to the Burt Harris settlement, though of course this is an amorphous discussion. I prefer at this stage that we limit our comments and questions and direction to the Burt Harris letter, and a motion or some direction would be helpful.
Would anyone like to bring a motion?
A motion, a 5-minute recess so you guys can talk about it.
This commission's, folks, please stop shouting. We've given you an opportunity to be heard. As a matter of Florida law, the only way this commission can deliberate is where they are right now. We cannot recess to a private room and have anything out. This is the legislative process. I don't have the luxury of meeting with my client individually as a body to get direction. I'm asking for direction from you, the commission. Please make a motion and give some direction relative to the agenda item pending.
John, would you like to make a motion? John Bigelow, are you there?
Yes, I'm here.
Would you like to make a motion?
No, not on this issue.
Okay. Jude, would you like to make a motion?
I would like to build on this issue after the other.
I'm sorry, we can't hear you.
Bond has stated he would prefer to handle the other issue first.
Handle the other issue before you.
3 hours.
I'd really like this commission to come to a consensus.
I'm not, Randy, you may need to help me word this. I make a motion that we not accept the Harris claim. Is that the way it would be worded, or to not go forward with the settlement?
If your direction is at this time that you do not wish the letter to be sent in its current form, the direction I would seek is whether if there's no settlement, if there's no settlement terms that you think suitable as a commission or wish to move on, when you look to Florida Statute 70.01 concerning the Burt Harris Act, it contemplates replying within 90 days to provide a response, and it lists a series of ways you can respond. I'm turning through it at the moment, trying to find the section. But one of those is no changes to the statement of allowable uses. So it's in 70.001 sub 4, sub C. It says during the 90-day notice period, unless extended by agreement of the parties, the governmental entity shall make a written settlement offer to effectuate, 1, an adjustment of land development and permit standards or other provisions controlling the development or use of land. 2, increases or modifications in the density, intensity, or use of the areas of development, which is generally the discussion that's being had this evening. The transfer of development rights, land swaps or exchanges, mitigation, including payments in lieu of on-site mitigation. Again, this is to handle a whole host of kinds of claims. Location on the least sensitive portion of the property, conditioning the amount of development or use permitted, a requirement that issues be addressed on a more comprehensive basis, issuance of the development order, a variance, a special exception, or any other extraordinary relief, purchase of the real property or an interest therein by an appropriate governmental entity, or payment of compensation. And the final one on number 11 is no changes to the action of the governmental entity. So any one of those, as they are appropriate for the claim presented, are your options. If your direction is not to settle the Harris Act claim, then in any way, then it would be no changes to the statement of allowable uses. I would modify the letter to reflect what those allowable uses are relative to occupancy to better reflect that, and that would be how I would proceed, provided that's the direction you give.
Can I make a motion for no changes?
Randy, I have a question. Everybody is concerned about other bigger properties wanting to do the same, have the same ability to have 14 people. If this passes with this one house and this ordinance passes, can anybody come for us to ask that? After this is passed, can they file a Parker Harris claim after we pass this ordinance if they buy the property and turn it into an Airbnb after all of this is said?
If a property is purchased subsequent to the adoption of the ordinance, then no, they would, well, let me amend that for precision of language. Yes, anybody can present a claim anytime. No, I do not think that claim would be meritorious because it would be adopted subsequent to the adoption of the ordinance. As you've heard the plaintiff here say, not hearsay in the law, the plaintiff who was present this evening say, their purchase was made before the enactment of the ordinance imposing an occupancy restriction, and that is the basis of their claim. Now that you have the 2023 ordinance with an occupancy restriction, and regardless of how you proceed on the ordinance tonight, you'll have an occupancy restriction of some sort in place, so that's distinguishable. Every claim would need to be evaluated on its own merits. There is no binding precedent created. That said, I hear the concern that the attorney is trying to scare people. My job is a risk manager. My job for a living is to tell public officials, here be dragons. Some of you are dragon slayers, some of you run off the map. That's your choice in risk tolerance. And I will march wherever on that map it is, and your litigation counsel will march wherever it is on that map you wish to go. My job is to tell you where the risks are. If I told you all the shiny, happy people sides of this, I wouldn't be doing my job. There is a possibility that we prevail on everything. As I told you, I've litigated Harris Act claims. I know this statute inside and out. I may be the only person in Florida who has listened to all the floor debate from when it failed in 92, when it succeeded in 95, and all the committee hearings and the donut hole comparisons. I know the statute. I say that to say, just as much as the sentiment is tonight that we shouldn't settle, maybe, that we shouldn't settle this, we should fight this, to send a message, and that makes sense. There is nothing that prevents anybody sitting in this room or not sitting in this room from presenting another claim tomorrow, whether we defend it or not. And I hear the who cares of it all, and that's fine. My job is to tell you, whether we settle this or not, other persons, other parties, other property owners may wish to file additional claims. There are limits to your resources in insurance and otherwise on defending these claims. In the city of Holmes Beach, which is, by the way, incidentally cited in their claim letter, in the city of Holmes Beach, we had several litigants present Burt Harris claims. When those claims were presented, we responded with a motion to dismiss in that city, saying that the comprehensive plan already covered and addressed what they were trying to do and they had no claim. And the court said, well, I'm not so sure. And then 3 years later, we got a judgment based on precisely that same argument. Nothing else. And it was nearly $1 million later in litigation costs between appraisers and other things. So I'm not saying it can't be won. Again, I think the point is well taken that win is defined for each of you just as risk is defined for each of you. There is a motion made to send a response providing no changes. Is there a second to that motion, Madam? I believe Mr. Bigelow.
Yes, John.
Mr. Bigelow says he has seconded the motion made. With the motion made and the second, Mayor, I think at this time this issue has been discussed exhaustively. It would be appropriate to call a roll. But I defer to you as the presiding officer. So the motion on the floor, to be clear, just for complete clarity in the record, apologies, Madam Clerk, I hadn't noticed you slipped out. There's a motion on the floor, I'm buying her a little time, folks, that's it. There's a motion on the floor to send a letter that says no changes. So a vote yes is for a letter that says no changes, a vote no is against no changes. You would not send a letter that says no changes. Is that clear to you? Like, yes, I just want to make sure nobody says, I didn't realize that's how I was voting. So there's the motion and the second. Member Wyatt has voted no. Madam Clerk, if you could continue to poll the council.
Commissioner Bond?
I want to make sure I'm clear on this no yes thing. No changes
is we do not settle this claim. You continue, we will proceed with, I can't say continue because it has not been added to the litigation yet, but we would litigate the claim. A vote yes is litigate the claim, a vote no is some other solution at this point. I don't know because there's no other motion on the floor. The motion on the floor at the moment. Member Wyatt has voted no against we only have one vote on poll. Actually, Member Bigelow is in the middle of voting, but we only have one vote on the record right now. And the question is, do you want to send a letter that says no changes, the practical effect of which would be we would litigate the claim? So, call the roll.
We're confused.
I answer to the commission. Commissioners, are you confused about the direction at this point? Because I want to make sure you're clear, you're the ones voting.
Not confused.
Mayor, are you confused? And it's not a criticism.
No.
I want to make sure you have clarity. The motion on the floor, made by Commissioner Wilson and seconded by Commissioner Bigelow, is there's a letter in the materials that contemplates a proposal to settle the claim. As my duty was to provide you legal advice, I've read to you the language of the statute. Commissioner Wilson then asked, what are our other options? One of those options is to say no changes to, no accommodation to this property, the practical effect of which would be we would litigate the claim. So, if you're voting for no changes, then you are voting against the draft that's in there, but a yes vote is send a letter that says no changes to or accommodations made to this property, the practical effect would be litigated. Is that clear, Member Bond?
Yes.
Okay, so Madam Clerk, if you could please call the roll.
Commissioner Bond?
No.
Mayor, Commissioner Hausberg? No.
And Commissioner Bigelow, I'm not sure if we got your vote on the record.
I do not want the ordinance to go through, so I guess my
We're not on the ordinance. We're not on the ordinance, we're on the Burt-Harris letter. Do you want the Burt-Harris letter sent in its current form? The proposal is to send a letter that says no changes, which is the motion that you seconded.
So is that a yes or a no vote, if I want to do that?
If you voted consistent with your motion, you would vote yes. So how
yes.
Okay, so by your vote of 3-2, the motion fails at this time. Is there a separate motion to be made?
I want to make a motion to send a letter.
Member Wine has made a motion to send the letter. Is there a second?
I'll second that motion.
The mayor has seconded the motion. All right, commissioners, the motion on the floor is to send the letter in its current form, which would, I hear a lot of people saying I'm confused. I'd like to do my best to try and resolve that, if you please let me speak. The motion on the floor is to send the letter in its current form, which would provide for an accommodation of up to 14 occupants, forget 2 and 4 math, 14 occupants at the property at 455 20th Avenue. There's a motion on the floor in a second. So, Madam Clerk, if you could please call the roll.
Commissioner Wyand? Yes. Commissioner Bond?
Yes.
Commissioner Bigelow?
You know, I have limited communication there. I apologize for that.
Commissioner Bigelow, the motion on the floor is to send the letter as written in the agenda materials concerning item 6A, a response to the Byrd-Harris Act letter. There is a motion and a second to send the letter in its current form, and we are seeking your vote on that motion.
Randy, I want to make this clear. I do not want the Byrd-Harris to go through.
Vote no on the pending motion if that's your position, Commissioner.
So if that's going to be the case, I vote no.
He can also amend the motion, can't he?
No, he's not the person who made the motion under Robert's rules. To amend the motion, you have to be one of the motion makers. But be that as it may, we've had an alternative motion go forward. If the commission wishes to do this, commissioners, please continue to call the roll, Madam Clerk.
Vice Mayor Commissioner Wilson?
No.
Mayor Commissioner Hausberg?
Yes.
By your vote of 3-2, the motion carries. That concludes the hearing on item 6A. I have sufficient direction from the client. We are now proceeding to item 6B, a proposed amendment to the short-term rental ordinance adopted in May 2023. As it seems there are several people exiting, I think we should take a moment, Madam Mayor, and perhaps recess.
Okay.
Can you take a 5-minute recess?
Yeah, the ordinance will be next, and we will be having public comment on that as well. But we're going to take a 5-minute recess since this has turned into a really long meeting.
Folks, we're going to resume.
I didn't yell at you. Child.
We can start to resume our seats here. We'll get started in just 1 minute.
So there's no reason.
So you're probably all looking at my bunch.
That's actually not this one.
Thank you so much, John.
All right, folks, Madam Mayor, as you resume your seat, we can meet with Madam Clerk. Are you ready to go back on the record? Okay. Madam Mayor, if you may.
We will proceed to the next public hearing, the first reading of ordinance 2025-01. Randy, would you read, please?
Thank you, Madam Mayor. This is item 6B. First reading of ordinance 2025-01. An ordinance of the City of Indian Rocks Beach, Florida, amending the comprehensive regulatory scheme regarding the marketing and operation of short-term rentals within the city. Amending Article 5, vacation rental regulations within Chapter 18 businesses, amending the ordinance regulating the registration, inspection, safety, and operation of vacation rentals within specified zoning districts in the City of Indian Rocks Beach. Amending related definitions concerning permissible occupancy, altering registration requirements, modifying enforcement provisions, amending inspection requirements, amending the duties of designated responsible parties, clarifying life safety requirements, making related findings, providing for codification, supremacy, severability, and for an effective date. This has been a first reading of ordinance 2025-01 by title only. As previously discussed, you considered an amended ordinance. The ordinance that this would amend is the ordinance adopted on May 9th, 2023 on second reading. We went to mediation and presented an amended ordinance back in August of 2024. At that time, that version of the ordinance largely mirrored the one that is before you. The significant difference between that one and this one is the proposed maximum occupancy, comma, provided the property has the size to justify it, can have 12 occupants as opposed to 14. That does not mean that every short-term rental gets 12 occupants. It is based on the dimensions of the property. One thing that changed, going through the actual substantive changes in this ordinance, I will walk you through them very briefly. It won't take that much because there's not that many. The first is in the definitions section. All right. Madam Mayor, before I continue, by your rules of procedure, ordinarily we need a motion to continue beyond 9:30. May I have a motion from the commissioners to continue the meeting?
I'll make a motion to continue the meeting past 9:30.
And I'll second the motion.
There's a motion to continue past 9:30. Can we have that through the resolution of this issue? Or other, okay. There's a motion and a second. All in favor?
Aye.
Any opposed?
No.
Okay, I will now proceed with the exposition of the ordinance. So the first definition, if you're looking at the ordinance, concerns the definition of habitable living space for sleeping purposes. This backs out the definition of living area, and the habitable living space for sleeping purposes is language derived and slightly modified by the county ordinance. One of the things that was discussed at mediation and presented here as an amendment between what you saw in August and saw now is the addition of the word offices. Earlier there was some discussion about all the places that people could be put under this new ordinance. The definition of habitable living space for sleeping purposes specifically excludes bathrooms, water closet compartments, laundries, pantries, foyers, communicating corridors, closets, storage spaces, kitchens, dining rooms, utility rooms, now offices if approved, garages, and unpermitted area below base flood elevation. So none of those areas go to the analysis of where people can lawfully be placed if this is adopted. So I believe there may be some misunderstanding around that issue, but I just want to make clear, none of those places are where you would be allowed to lawfully have occupants. The second significant or substantial change is in the registration process. Instead of doing this annually, it would be every 2 years for the purposes, and that's section 18-04. And there was language added which was consistent with our previous code, but clarified as it led to some misunderstandings in litigation as to the application of codes retroactively and how that would be administered. So that was to resolve and address some of that confusion. The next substantive edit you would find is, and there are others, but I'm trying to touch on the substantive ones here. 18210, inspection of vacation rentals. This changes the inspection scheme in a few ways. There is still an inspection required. There's been some misinformation suggesting that this removes inspections from the process. It does not. And that language is found in 18210. The next substantive amendment can be found in the advertising requirement, and this is 18214. This removes the requirement that there be a statement of a sign placed that says you are vacationing in a residential area. Please be a good neighbor by keeping the noise to a respectful level during the day and night. Excessive and unreasonable noise can deprive neighbors of the peaceful enjoyment of their property. This in no way backs out the application of the noise ordinance. It removes the required posting. So that's one of the provisions in there. There's also added language on advertising violations, clarifying or adding a provision that says nothing in this section shall prevent a property owner in the CT district from advertising the total available occupancy and immediately adjacent dwelling units that are under the unified ownership of an individual entity, so long as the adjacent dwelling units are under a single roof with a shared wall and an internal pass-through connecting the separate units. And the advertisement explicitly identifies the number of separate dwelling units correlating to the total available occupancy. So that does nothing to change occupancy. What it does is, if you have, for example, lockout units, so units 1 and 2, but they share a wall, they're under one roof, and those two units are owned by the same property owner, you can say in your advertisement, max occupancy 20, 10 in unit A and 10 in unit B. Just makes clear that it's not an advertising violation that way. Only in the CT district. Only in the CT district. The designated responsible party is responsible to make best efforts. That is still something that can be prosecuted. There's been some suggestion it cannot. It's just, again, establishing that. The most significant change is in the maximum occupancy based on site capacity limitations. And there's a few important points that need to be made when we talk about occupancy. Just in terms of the legislative change, the prior language had 14 up to a certain point, and then it would phase down to 12 and 1 to 12, and then it would phase down to 10. What this does is say flat, it's 12 occupants. 12 occupants if the math gets you there. So the actual language is, in all zoning districts to which this article applies, the maximum overnight occupancy of a vacation rental unit authorized in the vacation rental registration process shall be the lesser of 12 overnight occupants or the number of occupants permitted by the following calculus. And it breaks down various mathematical calculations based on the square footage. It basically comes down to square foot. So it's 12 overnight occupants, and then if the lesser of 12 overnight occupants or the number of occupants permitted by the following calculus. In every dwelling unit, every habitable living space occupied for sleeping purposes, so not bathrooms, not closets, none of that, for sleeping purposes by one occupant shall contain at least 70 square feet of floor space. Every habitable living space occupied for sleeping purposes by more than one occupant shall contain at least 50 square feet of floor space for each additional occupant. So if a room has 70 square feet, it gets 1. If it has 120 feet, it gets 2, and so forth and so on. In addition to the occupancy limitations set forth in A and B, the property shall be granted 4 additional occupants, and under no circumstances shall the calculus set forth in this subsection be construed, interpreted, or applied in a manner to allow for a maximum overnight occupancy in excess of 12. 12 is the number at max, but at 12 is not the entitlement. The property has to have the dimensions that allow for 12. And then the final substantive change is in the life safety section of the ordinance. And forgive me, again, all the noise ordinance stuff is still in there. And some of the other required postings and things are still in there. But the final substantive change is on fire and life safety requirements. There were a series of requirements, some of which were not in direct alignment with fire and life safety codes. And to avoid any conflict between and confusion that created between the two, it now reads, each dwelling unit operated as a vacation rental shall comply with the applicable provisions of the Florida Fire Prevention Code and any modifications or amendments thereto adopted by the Pinellas Suncoast Fire and Rescue District or any successor entity serving as the authority having jurisdiction to interpret, modify, and administer the Florida Fire Prevention Code. Which is to say, fire and life safety will be administered by the fire marshal, who has that competency and who's provided that authority by statute. Those are the substantive changes. Now, back in context, we were sent to mediation a second time. This is the proposed ordinance. If it is passed on first and second reading, because it needs to get through both, if it is passed on first and second reading, based on your direction on the first item, that would settle all 7 suits. If it is not passed, we would still have to litigate the validity of the city's ordinance. Though based on your direction, we will have settled that for Harris Club. So at this point, I'm asking for your direction on what you'd like to do, how you'd like to proceed, and of course, before you give me that direction in the form of a vote, this matter will be open to public comment. Do any of you have any questions about the ordinance itself or the procedural posture ordinance? The commissioners?
I don't have any, but right now, if we don't make it through, we don't have an ordinance right now.
No, we have an ordinance, Mayor. We have the ordinance adopted in May 2023. That ordinance is on the books, and we are administering. Your city administration is administering that ordinance. We are taking registrations. They've conducted inspections. They have been administering the ordinance as adopted in May 2023. If you do not adopt this change, we just continue operating under the ordinance adopted in May 2023, and we litigate the validity of all the issues raised in litigation. So our ordinance is not somehow presently void because it's being challenged. It's not void until the judge says so.
Okay. So, but will we potentially be led right back into mediation?
Potentially, maybe not, maybe so. I don't know. I cannot pretend to predict the winds of the Middle District of Florida at this point. And I don't mean that derisively to the courts. I can't predict what direction we will be provided at this point procedurally. We are already in a procedurally unorthodox process.
Randy, would you say it's fair to say that that's the totality of the major changes from the standing ordinance?
Forgive me. Thank you, Jude. As you posed that question, there is one thing I failed to mention. The one, I was looking at the added language. One significant change in terms of the totality, the other significant change I failed to mention was the elimination of the suspension and revocation language in your ordinance. And so, I wish you all success in your careers and that you may never omit a thought as you recite extensive items in a 4 or 5 hour meeting. Thank you for your grace. So with that, I failed to mention the elimination of the suspension or revocation language. I was not obfuscating the issue. It was an oversight. My apologies. The suspension and revocation language in your ordinance can be found in other ordinances in other communities. Based on my diligent review, I have yet to find a community that has actually done that, suspended or revoked. Our ordinance has been in place since 2023. The way that the suspension and revocation is written attempts to resolve all due process concerns. In order to have your license suspended, it is not based on complaints. It is based on adjudicated violations in a set period of time. Based on the administration of our ordinance to date, nobody comes close. Based on what you've heard from some of the litigants and otherwise from your administration, our code enforcement through fines and hearings has effectively garnered the compliance that we sought in other situations. And so at this stage, because there remains a challenge to this, those cited there's no appellate authority analyzing this issue in this context. That language has been removed for purposes of this. And I wish to make another point. After the August hearing, or during the August hearing, we listened. Your commission listened. We listened as the attorneys handling this. And one of the phrases that kept being said was, what are we getting for this? And at the time, my response was, what you're getting is, again, the certainty and control of resolving litigation. Because understand, our postures are different here. When the city adopted the ordinance in May of 2023, it wasn't leaving things on the table saying, well, if we're sued, this is what we'll add to the ordinance. As many of you said, you had the ordinance you wanted. So it's now been challenged. And when you talk of compromise, that means addition by subtraction. The addition of a solution by removing language is the only way in this policy discussion to approach this. And so in going to mediation, we had the challenge of saying we don't want to change anything else in the ordinance, obviously. And they have the challenge of saying, well, we don't want it as it is. And we had a mediation, we came up with what we were willing to do, and now we're being sent to go back. And we have to negotiate in good faith and find somewhere where we can find the give. And most of the discussion during the last hearing focused on suspension and revocation and occupancy. And because my commission has changed several times since this was adopted both in 2018 and 2023, I've told you from day one, occupancy is where the litigation is made. And that's where we are. And so occupancy is where the discussion was had. And so the proposal is to go from 10 maximum to 12 maximum if the dimensions of the property get you there, and not all dimensions get you there. Most properties are not large enough to sustain that based on the ordinance as written. That said, I'm happy to answer any other questions.
Does anyone have any questions of Randy? No? Do you want to discuss it now, or do you want to wait till after the public comment? Okay. All right, I'd like to open up the floor for public comment to discuss the first reading of ordinance 2025-01.
Can I ask Randy to articulate more clearly the changes to the inspections that are proposed?
When you have a comment, ma'am, you're free to come up to.
But you never respond when you say something. Right? You're not allowed to? So
I'm not going to do the back and forth, but yes, I will be addressed. I don't want to intrude on your folks' turn to talk, but it will not be ignored, ma'am. I'm making a note, I'll address it. I want you folks to have your opportunity to speak.
Don House, 21 Corby Street. The question I really have is the ordinance that we have now that is going to be changed a lot. Is the ordinance we have now defendable in court based upon the rules that have been thrown down by Tallahassee? If it's defendable based upon what Tallahassee has said, then why would we change it? If it's not defendable based upon the rules from Tallahassee, we have to change it. So that's my thing, is like, we don't need to open up the city to every lawsuit from everybody. But if it's defendable, we shouldn't change the ordinance. But if it's not defendable, we should. So if you have an opinion on that, Randy, I'd love to hear it. Thank you.
As it may inform additional comment, I wish to, and ma'am, may I answer the question first? As it may inform? Okay, thank you. To address Mr. House's comment, and this was discussed during the August meeting, the question posed casually is our ordinance legal? Like, is our ordinance in line with the statute? And I give you the improv answer, yes and. Inasmuch as the 509-032 7B preempts our ability to regulate duration, frequency, or otherwise prohibit short-term rentals, it is my position, and I've litigated this issue, that it is in compliance with that particular preemption. Now, some of the litigants are challenging that. Now, I don't think it's in every claim, though it might be, I'm trying to remember. But that is at issue in the litigation, and we would have to resolve it. We've written a motion to dismiss that sets forth our argument, cites case law on it. I think we win on that claim. However, I don't know, but I don't see anything in our ordinance that actively prohibits duration, regulates duration, frequency, or prohibits the operation. So when you say, is it compliant with the rules from Tallahassee? Yes, as to that. But when I say yes and, the challenges raised are constitutional challenges as well. First Amendment, due process, takings exaction, kind of, sort of, at least one of them. And so those are claims that there is not clear, decisive case law to say how they will resolve. I continue to believe all our claims are defensible. I would not have written an ordinance knowing full well that that there was no defense to the position. some more defensible than others, and we'd have to see how a court resolves it. That's the process. But is it, the easy question of is it legal is not quite so black and white, because there are a series of challenges being posed. On the one that most people focus on, 509032, the Tallahassee regulation about duration and frequency, I think we're on very good standing there. But that's not what all the litigation is about. Were it that, this would be a very different discourse. So that would be my answer to that. Because I'm now in the position of answering questions, with your indulgence, ma'am, I'll just address the inspection language. Words matter, so I'm just going to read the words. Each vacation rental shall, and this is the new language proposed, each vacation rental shall, in conjunction with its initial and renewal applications, be inspected by the city's code inspector. That is, shall be inspected. A representative of the fire district service in the city, and to the extent necessary, the city's building official or designated agent thereof. The city's code inspector shall inspect the property for compliance with the provisions of this article and the city's code of ordinances. The city shall provide vacation rental owners with a checklist identifying the items that will be inspected during inspections. And again, that's a notice issue and a due process issue. And one of the concerns that was raised, that is this a moving target or is there a definitive thing you're looking for? Any inspection conducted for the purpose of determining compliance with the Florida Building Code and the Florida Fire Prevention Code shall apply the versions of those codes that were in effect at the time of permitting approval for construction of the vacation rental structure, unless those codes include explicit language requiring the retroactive application of a provision or subsequent modification of the dwelling unit or structure otherwise triggers the conditional application of a provision within those codes. So for example, I think I said this at the last hearing, many years ago in my house, I decided to close in a room. It was an open living room that ran along a floor room. I closed it in, and when I did that, the fire inspector looked at my plans and said, oh, you need hardwired smoke detectors now. And I said, well, that wasn't applicable to the house. I said, well, yes, but now that you've modified the interior structure, it is a requirement. So if those kinds of things come up, then those things would apply, but we're not just going to make them apply because to a home built in 2002, everything that was adopted in 2025 suddenly becomes. So but the inspection is a shall. There's been some suggestion that inspections come out of this. It's not. There's been a lot of discussion about gutting the ordinance, and I understand that visceral reaction, no pun intended, but by and large, the provisions remain. There is still an occupancy restriction, there is still an inspection, there is still registration, they still have to comply with fire life safety codes, no one is saying otherwise. Ma'am, I yield the floor to you as public comment, apologies.
No, not at all. I am not, oh, I'm sorry.
There we go. I already know how it's going to be voted because you showed us how. Oh, I'm sorry. Patty Katz, 124 13th Avenue, Indian Rock Beach. I already know how you're all going to vote. You disappointed us, and I also take exception to anyone on the commission that reached out to someone that is suing our city and had conversation, and that person stood up here and said he confirmed it with someone on the commission. So I'd like that to be looked into. I know how they're going to vote. They don't care. They don't want to listen to the residents. This group has single-handedly ruined our community. Jorge and I will be moving. I know you all are happy about that, but we took great pride in where we lived and participated in every one of these meetings to show that we're a part of this community that cares, and so does everyone here. But we do not want to be a part of a community that has people that are put into place, not even voted, that guts what we want and just does what they want against what the community has to say. We're appalled. That's all.
Hello again. I'm still Bob Copeland, 447 20th Avenue. Thank you, again, thank you for your patience. I don't usually say this very easily, you know, because guys don't, lawyers don't. Randy's ordinance regarding the violations is superb. The existing draft is superb. It covers every aspect of due process. It gives every element of justice that I've seen in court in thousands of hearings. There's no reason why it needs to go away. Why would it go away if you're not a problem? The way the ordinance is to be changed, it's just a in-your-face die. You can have the cops at a short-term rental 60 days in a row. Criminal violations, arrest every single day. And you can't suspend them. That's what that wonderful world of in-your-face sport litigation provision says. Look at it. We had on 20th Avenue, just before I went away in September, the police 3 days in a row, not at this house, but across the street down the road, prostitution and grand theft. 3 days in a row. Oh, we don't really care if that happens. And we can't do anything about it if we gut the existing ordinance provision. That being said, I'm trying to not overcome what I pointed out before, that the fire marshal has been served by the Gunster firm. We don't have a choice. People knock on my door today I never met and gave me checks for the fund. People stop me here and say, where do I give you the check for the legal fund? It's not me. I'm just a mouthpiece. Like, I'm sorry I forgot his name, from Mr. Phelps Dunbar. He's just a mouthpiece. I'm just delivering the news. No license, your license is revoked, you don't comply, you don't have a contract, you don't have standing to sue. You don't have claim for damages. Reapply for a permit when you're compliant. You get it under the 2023 standard. You can't beef about the caps. You can't beef about the rules in the ordinance. They were there. That being said, I got a lot of things here to say, but the 509 fire safety encompasses all public lodging. The 553895 that's in our fire lawsuit that I've given says all public lodging and has a provision for including 509s. So it's not only hotels. So what you're trying to do, unfortunately when I say you, I'm getting personal, you're going to have Holiday Inn have stricter rules than a short-term rental with the same license.
Working in Lucina, 124 13th Avenue, I yield 3 minutes.
Oh, I'm sorry, I forgot to ask. I think I have a couple others.
Jorge has gone Ranford on yielding his time. Is there anybody else who would yield their time to Mr. Copeland? He gets a maximum of 10 minutes. Ma'am, what is your name?
Lori Ferris, 472 Harbor Drive South.
Okay, could you restate your name, ma'am?
Lori Ferris, 472 Harbor Drive South.
Lori Ferris, 472 Harbor Drive South. That's an additional, that's 6 minutes. He has up to 10. Is there anybody else who would like to yield their time to Mr. Copeland? Ma'am?
Mary Jane Arbertine, 514 20th Avenue.
Mary Jane Arbertine with Jorge, Mary, and forgive me, ma'am. All with those 3 people, you have 7 minutes remaining.
I forgot to bring that up.
You have 7 minutes remaining, sir.
So the tragedy of turning it from living space to habitable space is a conflict of the written Florida statutes for bedroom. You're being asked in this dream machine draft shoving down your throat, or we're going to sue you, to violate or try to overcome or undermine existing Florida statutory provisions. Look it up. I'm telling you right now, there's many minefields in here. This ordinance, as proposed, has a blatant violation of a state fire marshal safety code. I'm not telling you where. I did my research. I can cite statute and paragraph. Go ahead. Now you're gonna get the state fire marshal raining fire on you if you deal with the things they've got in here. Pardon the pun, raining fire. There's nothing wrong with our ordinance. If you don't misbehave, why do you care? If you don't have 200 kids at spring break and 5 sheriffs showing up to arrest and cart off 200 kids from a house that they say should have 14, you won't have to worry about those rules. If you don't have day events where they're blasting party boats out back and disrupting the neighborhood, you don't have to worry about changing the rules. Our ordinance is fine. It's just they're trying to bluff you when you have a royal flush and you have checkmate on them. And they're trying to intimidate you with the money part. Go ahead. You just passed the Bert Harris letter. You don't have to agree to this. And if you want to make a couple changes, maybe. But there's nothing that says you have to pass what they are unmercifully put on the city with its conditions. And I'm telling you, there's traps everywhere. I didn't bring them all here. That's not my job. But I'm telling you, I already saw them. There's a lot of traps for the city. You're going to get set up to be sued, just like the 2018 ordinance changed. Changing which code you say they have to file. Then when the county comes after them, you're being sued because they relied on it. I have a 1957 structure. I remodeled it in 2018, just like Randy. They made me bring it up. They didn't let me stay with the 1957. That's a trap. You're going to get sued because you said it was okay not to. And some official says they have to, the state or county. Oh, we're suing you for the money because you said we didn't have to. It's just trap upon trap. You have to understand that's the game. That's the way it's played. Anything they put is to help them. Anything they took out is to hurt you, help them. There's nothing wrong with the ordinance. Just refuse it and let them have their Bert Harris. What's wrong with that? What's wrong with that? We already refused to change the ordinance. It works. I'm sorry that the citizens are not happy. I'm sorry that the people that are now financially burdened are dropping checks off left and right. It speaks volumes as to where the citizens believe. I know this is not an interactive question and answer. I did send some emails. I'm trying not to overcome. I sent one today. Florida statute 509-281. Within the public lodging statute, the Airbnbs, 509-281 said, failure to comply with any provision of 509 is a criminal violation. Any provision. There's multiple that I can tell you they don't comply with. How about keeping their, whatever. I haven't sat there, but I know they can't pass fire safety codes. Look at the Airbnb pictures. Look at the appraisal they gave you. You can see there's no fire suppression. There's no exterior means of egress from the 3rd floor. One violation, they didn't get their fire safety inspection, and it's ongoing business. It's a fact. I didn't write the statute. It's a criminal charge. You want to let a criminal get away with stuff? It's rampant. I can go through the list of things that in general are probably not met because they're just overlooked. It's a criminal charge. You got a copy. I didn't write it. I don't know what else to say. I got a lot to say, but I don't want to just keep going on. Criminal violation under the 509 statutes for non-compliance. I didn't write. I didn't make up. How do you ignore it? How do you reward it? How do you let it continue to occur? The citizens don't want to have to force it down. But I'm just pointing it out on their behalf.
Thank you.
You can always ask me any question in private at any time, if you can't, do it now, I have no problem asking, meeting with one of you, I know how the rules work. You can't meet together. I would happily meet with the manager, any commissioner, Mr. Mora, one-on-one, under the rules of the Sunshine Law, if you all wanted to interact.
Thanks, Bob. John.
Hello again. Numerous times, our city attorney has said that he does not want to influence you. He only, I'm sorry, John Cleanstill, 448 Hoover Drive South. He only wants to provide information. From my perspective, I have seen it going in one direction far more than the other. If you go back to the August meeting, there were many things that were listed that were negative if you didn't vote to change the ordinance. There was none that was positive. Tonight, we're talking about the Bert Harris issue. What was the last thing you heard? That their firm charged $1 million to settle Bert Harris even though it won. I understood that correctly.
You did not.
Okay. $1 million to settle a Bert Harris firm, whether it's your Bert Harris clan. In other words, that was the idea that was left with you. And tonight, we heard about these individual changes, suggesting that there are fairly minor. Let me go into this. Increases maximum occupancy. In most housing, it deletes the standard definition of bedroom. Now they come up with an entirely new term, newly invented, habitable space for sleeping purposes. This is exactly what the short-term rental industry has been trying to get written into law for years, statewide, if you remember. It sets a very dangerous precedent statewide, and the consequences could be devastating to neighborhoods. It's no longer a bedroom. It's 50 square feet in places. That means buildings that are, 1,500 square feet, they can pack more people into it. Granted, it supposedly won't go past the 10 or 12, but places that normally be 6 people are going to go up to 8 or 10. Again, it eliminates any effective enforcement by deleting the ability to suspend or revoke registration. That's what's held over people's head. What will happen when our party house owners know they can continually allow bad behavior week after week because they are immune to losing their registration? I don't think it was properly stated about the big changes to inspections. This allows registration before safety and code inspections. That's a huge deal. And if I remember right, it does not require yearly inspections. Again, a good thing. I would go in the other direction. You should be able to have spot inspections because like these people can dismantle those bunk beds on the ground floor if they know they're going to be inspected and they set on a time. And lastly, I don't think it was mentioned, it eliminates so much accountability. It changes things like only best efforts are required to handle problems. If there's a party going on in a house, instead of somebody responding and taking action and taking charge of it, they just have to say that they used their best efforts. And when it comes to filling out forms, if they lie in the registration forms, we have to prove that it was intentional for anything to happen. Just imagine what that would be like in other laws. I ran over a kid. You can't do anything to me unless you prove it's intentional. So, anyways, it's unfortunate that this huge change to the ordinance is being done and pushed by a commissioner that was not elected and another commissioner that just walked into office. The people will bring these regulations back if you let them go. Bye.
Hi, my name is Scotty Vaughn, 301 Harbor Drive. My husband was on the commission when these ordinances were put through. And I know the heart, the sleepless nights, the blood, sweat, and tears, the amount of time that not only him, the rest of the commission and this community put in, how well thought out this was. This was not spontaneous, some knee-jerk reaction. There was so much time put into this. I'm looking out here and I'm like, half of these people didn't leave because it was late. They left because you just broke their hearts. You just broke them. And my heart is broken. But it can be mended. You don't have to vote this straight line and vote the same way that you just did. I was a claims adjuster for the Hartford Insurance Company for about 10 years. And I handled claims like this all the time. We had insurers who were municipalities in Tennessee. And sometimes it was better to settle them. Wasn't worth it. Wasn't worth the time, expense. But sometimes you had to make a stand. And there had to be a principle that was set. So that the next person that walked through Walgreens and slipped and fell when there was nothing to slip and fall on, people knew. They weren't going to just roll over. And that is not us, you guys. We have just been through hell that Mother Nature rained on us. We had no control over that. We have control over this. And it is our turn to stand up and do what is right for our community. So you can walk down the street with your head held high, that you are doing and you are listening to what is being said in this community. I beg you to please do the right thing and do not change these ordinances.
Hi, Diane Daniel, 309 10th Avenue. Maybe it's too late for this, but I guess since we're having a second reading hearing vote next month, you know how when you get new terms from all these different internet providers and whatever, and they say, we've changed our terms, here are the main highlights? I would love to see a list that Randy said in writing. I would love to see what it was before and what it is now. It would be super helpful because I feel like I'm still confused. I've seen different sides say different things, and would be really helpful to see that if it's possible. So I have a house that I live in half year and then I rent it the other half. So I see both sides. The short-term rental rules were a total hassle for me to deal with, and then I dealt with them and it was fine. And it was not really a big thing. You do it one and done, and then you have your inspection every year. It was really just onboarding. It was a lot of work, but fine. The fee was, I think, $400 a year, which is nothing compared to the income that people get. So I know how much work went into coming up with these rules, and I know one of the things, I think you said, Denise, when you first started talking about it and then stopped, is that the changes are small. So I feel like if the changes are really that small, why do we have to do them at all? So I have to think that they're really bigger because that's what the investors want. And I don't think we should give it to them. I feel like that it's fair. We spend a lot of time with it. So I hope it stays. But more than anything, I would love to see detail of what is new with the new rules.
I'm sorry.
Oh, yeah. I was putting it down.
I'm just putting it down.
for those with a copy of the agenda materials in front of them, and I understand you're talking about a white sheet, but for those who are unfamiliar with how ordinances are drafted and amended, the full ordinance is before you. Any text that's stricken through would be removed. Any text that's underlined is being added. And I understand what you're asking for, but I just wish to clarify that.
Beth McMullen, 481 Harbor Drive South. When we're talking about occupancy, our town is going to fundamentally change because of these hurricanes. We're losing more houses, we're losing more residents. I don't know how many of these houses are going to be gutted, torn down, and rebuilt. I think about Sanibel, I think about Fort Myers, and I wonder what has happened to those communities. So I looked it up. Homeowners told News Nation that wealthy newcomers have been buying beachfront properties because they have the financial resources to rebuild right away. It's a great opportunity for investors to come in, buy those up, and build larger, more up-to-date homes that they can turn into rental properties and generating income. That process is reportedly happening nationwide. Realtors say the rich are reshaping communities battered by hurricanes, fires, and other major natural disasters. Back in Southwest Florida, residents worry Fort Myers will have a different vibe when wealthy folk are done buying up land and rebuilding. There are those that want to hold on to the funky beach vibes that it used to have, and there are others that are ready to build multi-story concrete hotels and things like that, turning it into something like Miami Beach, Oak said. The rebuild in Ian hit communities is still ongoing, and there's still a way to go before anything really takes shape. However, the concern remains that the communities will lose their character. Let's talk about adapting. Let's talk about the change. We know this. We know that they're going to come in even more. So when you're talking about occupancy and these ordinances, think about how our neighborhoods are going to look, not now, but in the future, in the near future. And think about the motivation that these investors will have to build these multi-unit, large unit homes so that they can have 12. When you look at my neighborhood and where I live and my cul-de-sac, the homes that are currently now short-term rentals that are large, that will qualify for this 12, that is an entirely another house stuck just in those few houses that are there now. So it's only going to get worse. I've seen this happen. We all look at the current and we don't think about how it's going to change. So we have the ability to set a standard for our community. Are we going to just let all these people come in and just multiply the amount of people by these 12s? Or are we going to think about how we can set a standard from here on out?
Matt Kinez, 111 Canal Avenue. Just a couple points I guess I have for the commission. Probably not going to be favorable thoughts with the community, but a couple of things I think just to think of in terms of rebuilding. I mean, any investor can come in and rebuild and build condos that then can have 6, 8, 10 occupants in each one. 2 doors down from my property is a 3-unit building on the same size parcel that I have. So if my property was to be demolished, 3 condos can be put in its place, and there goes that occupancy, no matter what the occupancy is. There is a size restriction, so obviously that's going to bear it. The other question, I don't know if it can be answered by Mr. Mora or the attorneys, but do we have any recommendations from our 2 attorneys in terms of for you to consider on what they think that you should do or what the recommendation is based on how it sits? But the other thing I think that should be thought of would be that not all short-term rental owners are big conglomerates, right? I mentioned to myself, it was for my family and I to come down here. The other reason we're not living here full-time is because we purchased up north in Florida, 40 minutes away because of school systems. So in terms of the amount of money being spent, like that's not talked about anywhere in here, is just the community and the school systems. I have an 8 and a 6-year-old. I didn't want my kids to go to the middle school and high school that we were districted for. So I think there's other ways that money can be spent. And then in terms of the last point that I would ask you to consider is removing the penalties that are in place. In terms of most of these short-term rentals are corporations. Does that stick to the house, or is that just the ownership in that corporation? Because it's very easily just to change the ownership of a property if somebody is a bad apple, to start a new LLC, swap the ownership of the property, and then they have their license again. So in terms of that being a big issue, I just don't see it being one because ownership can change like that. So in terms of I think the spirit of what's been proposed is that it is a settlement on both sides in terms of being able to just move past this. And I do not envy your position that you're in, and no matter what, I appreciate your guys' time.
Dan Minesburg, 442 Harbor Drive North. Some years ago, we pushed our city to enact some very reasonable rules for conducting a business in a residential area. And some of those most important rules were life safety rules. When a stranger stays in an unfamiliar building, they need to know how and when to escape an emergency. It's simple, but it's extremely important. I spent a career as a firefighter, EMT, and a command officer. I've seen what happens in houses that have too much occupancy. We used to refer to them as boarding houses. But this occupancy rule, now they're talking about like living rooms and lanais. All these things can be converted to habitable sleeping space. Big difference in definition between what a bedroom is. Okay, we're going to start taking these smaller houses. We're going to allow 12 people in them. The city's going to have a lot of liability. One of these houses is going to get lit up. You get a lot of people partying at night, a lot of drunks. They don't know the way around the house. If we don't have all the rules, we're going to have a lot of life safety loss. That's the reason that we had such a thing as hotels and the rules that they had. Now you're trying to move them into residential housing and then gut the rules. And I will use that term, we are gutting the rules. We're trying to reduce these. And there's going to be some big life safety concerns. That's it.
All right.
Two mics left, somebody dropped out. Well, it's been a long night.
Kelly, can you please say your name and announce your name?
I'm Kelly Cicerek, 448 Harbor Drive South. I think your smartest choice tonight is a vote to table this ordinance until the outcome of the Bert Harris settlement case. The Bert Harris case is in state court. This case is in federal court. And you had a response deadline of February 3rd for the Bert Harris. And you now met that deadline by submitting a counter offer to the plaintiff to give AP6 more occupants. You don't know if they're going to accept that or not, because they wanted 2.6 million, not 4 occupants. So why are you trying to pass this ordinance tonight before you know that result? They're your lead plaintiff. They're the money behind all these lawsuits. So the ordinance mediation case you're hearing now is in federal court in mediation. And this motion to accept this ordinance is gutting our annual inspection requirements. There's no more annual inspection requirements. That takes all the teeth out of our ordinance. And you're trying to be forced to accept a weird plaintiff-imposed substitute definition for bedroom
that's gonna set up city liability for violating state fire codes. I think you need to take a step back and wait and see your options after your lead plaintiff, AP6, responds to your Bert Harris case. You don't have to accept an ordinance tonight that the plaintiffs wrote for you. Thank you.
Commissioners, I wish to clarify, there are no state court proceedings between the parties. There are only cases in federal court. The claim presented under the Bert Harris Act under 70.001 is a state law claim, but it can be added to a federal court proceeding based on pendant jurisdiction and supplemental jurisdiction. So they have the ability to amend their complaint, potentially, to add the claim were it not settled. Based on the terms tonight, I believe you've settled it. And the only reason I say I believe is I don't have an executed release yet. I just wish to make clear there are no state court cases that I've not told you about. You have 7 federal cases pending.
The City Hall? Yeah, currently is R.B. Johnson, 1206 Beach Trail. If I'm not mistaken, earlier in this meeting, the city attorney said that he had helped put together an ordinance that he believed was a good ordinance and one that was defensible. And I think it was an ordinance that, by and large, the majority of the folks in this city supported and were happy to see put in place after a lot of time and work and effort was put into it. And it, as much as possible as it could, it made the citizens of this city happy. The job of the city commission, as much as possible, is to make the citizens of the city happy with their actions and with the things that are under their control. Not to make folks who are opposing the actions of the city happy. So who's afraid of bedrooms? Well, somebody who's unhappy with our ordinance, and there's a reason why that change isn't going into place, or they're trying to put it into place. It has ramifications. That definition or the elimination of it into habitable space has quite a few ramifications, reverberations that I don't have time to go into, but others have mentioned. But that's just one part of the minefield out there. I think that the commission made an error in the previous vote. I would ask you now not to compound that error. Now is not the time to tell the citizenry of the city that you are not happy with their opinions, because they need to be listened to. And there's a time to make a stand, and there's a time to give a message to the greater community out there. Now's the time to do it. It was done before when this ordinance was passed. It is, according to our city attorney, in his own words, a defensible ordinance. It's a good ordinance. Stick to the ordinance and make the citizens of this city happy with your job, the job that you're doing once again. Thank you.
Would anyone else like to speak?
Good evening. Eddie B., 497 20th Avenue. I tend to agree with most of the things that everybody has said here, and I do tend to agree that the ordinance has been gutted. What is the issue if there's no ramifications? Okay, if you break a rule, there's no, you can't do anything. They can do it 100 times. They're there. There's only one reason they don't want it there, because they still want to be bad actors. Okay. You need to put the provisions to suspend and revoke licenses back in. If I, as a realtor, don't do my continuing education and put my license in, and verify that it's, that I've done my education, I don't get a license anymore. Immediately it's gone. Okay. Everybody needs to follow the rules. There's a lot of rules that are here, but I haven't seen a lot of people following them. I drive around, I see a lot of Airbnbs that are up right now and running. Okay, how is this? Who is enforcing the codes? How are people going in and rebuilding and having an Airbnb running 3 weeks after a storm when the house across the street had 4 feet of water in it? Impossible. 18th Avenue. So, my family's lived here for almost 80 years, continuously. Somebody in my family has lived here since 1926, and still does today. I have seen more changes, and this has got to be the worst change that I've ever seen in this beach. And I'm sorry to say it, but lost confidence. Thank you.
Anyone else like to make a comment? I'm closing the public comment, or did you have a comment you wanted to make?
Yeah, one more about the rules. I don't see how any organization or any idea can run without enforcement. And we're a country of rules. We all have rules to live by, whether they're religious, whether they're county, whatever. You have to have rules. If there's no consequence, as a child, there was always a consequence. That's how people learn. And you guided behavior. You need rules. And I'll tell you a quick story. A Fortune 500 company, once like the slip and falls that somebody mentioned in some of these big stores like Walmart and whatnot. At any given moment, they had quite a number of lawsuits against them. And the company realized they were labeled as an easy target. So the next attorney that came on board decided that wasn't going to be the case anymore, and they tried every lawsuit. Well, that soon went away. Sometimes it costs money, and you just have to stand up and fight for your principles. But there have to be rules. They have to be enforced. They can't be enforced without inspections. And if something is working and it's not broken, why fix it? And what I'm hearing, a lot of people spent a lot of time and effort making a good ordinance. And what I don't understand is you're doing the people's work. People voted for you in some cases they didn't, or you were put in. But to hear such a loud outcry of the community to do something, and then to do just the opposite, I have a hard time understanding that. We're all trying to coexist. We're all trying our best to get along with the next door STRs. But they want more and more. They don't need more. Let's just work with it so we can all live together. And as you say, they're not going away, but let's try to work out the best deal we can.
Joe, state your last name.
Oh, Joe Mulling, 461 20th Avenue. Thank you.
Is there anyone else that would like to make a comment? I'm going to close the public comment on the first reading of ordinance 2025 and open it up to the commission for discussion. Randy, do you have anything to add?
Yes, Madam Mayor, I just wish to address a few points. Inspections are still compulsory in the proposed ordinance. Yes, it changes from annual to every second year. That was based in part on the way other ordinances works. Administrative scheme relating to the same, the administrative regime and resources that it takes to inspect every single one of these in a year. And so having them on a 2-year cycle seemed a sensible and reasonable amendment. And so that was one of the ones that was, but inspections are still compulsory upon registration and upon re-registration as written. The second part of it is that there's no enforcement mechanism, and that's just incorrect. It is flatly incorrect. There is still enforcement under Chapter 162. Admittedly, the element of suspension and revocation has been removed. While I am fully aware, as a member of the Florida Bar, that licenses can be suspended and revoked in various industries, as it relates to this industry, which has a very strange interplay with property rights and the way that the legislature has legislated around that, there is at least an open question on suspension and revocation as it relates to that. And that question is presented in litigation. From the city's review to this point, again, I developed a process that I think balances the due process concerns. However, as the city looks at the approach to a compromise, there are no properties that have come close to getting the number of violations you need in a certain window to get there. And to the extent any property has gone through the code enforcement process, we have gained compliance. I will never tell you you won't have additional violations of your code. I'll never tell you if you keep the old one, add the new one, you'll never hear noise, you'll never have parties. That's simply not how life happens. But I just wanted to clarify those points raised as it relates to the proposed ordinance. I'm happy to answer any questions you have based on the discussion at this point, and I believe I've addressed the questions that have been raised in public comment.
Does anybody have any questions of Randy?
I have a quick one. Can you go back to the description of what we're not allowed to restrict? So duration?
Under 509.032.7b of the Florida statutes, a municipality cannot adopt any restrictions that were not in place before 2011, restricting duration, frequency, or otherwise prohibiting the operation of short-term rentals in any zoning district. So you can't prohibit them. You can't say they're only allowed up to a month or 3 weeks or 2 weeks. So the natural solution to this is to regulate duration, frequency. We're not able to do that. At the top of this hearing, I stated that we are left with only imperfect solutions, and that is what we have. We have an imperfect solution in the form of our 2023 ordinance, and that it does its best to adapt. You have claims now, and again, my job as a risk manager here at eDragons, you have pending litigation, you have an opportunity to resolve it as the board has directed us to try and do on 2 occasions. And so in good faith, we went to mediation. In good faith, you have this before you. I stated a moment ago that I didn't, that I addressed public comments. This doesn't answer your question, but I feel I need to address this. There's a comment made that I told you my firm spent $1 million to settle a Bert Harris claim. I litigated, and I said we filed a motion to dismiss that I felt had arguments that would resolve that case immediately. We litigated that. We took depositions, we reviewed the appraisals, we did everything. And we won on summary judgment, and in other cases on motions for judgment on the pleadings, which is a less commonly used procedural device, but we prevailed with a judgment in 12 different cases. The claims presented were of 2 ilk. One concerned occupancy, another concerned the structure and the layout of it. We settled 4 out of the near 4 dozen that were presented, because those were based on the bedroom claim. All of the occupancy claims we prevailed on, and so those were seen through to judgment. I just felt I should address that, and we addressed the duration and frequency issue in that litigation as well.
So I'd like to mention to everybody, of course, that Denise and I are the only 2 on the commission that were here when we devised this ordinance that everybody is so attached to. Y'all weren't that attached to it when we came up with it because you all wanted more than we gave you. But we gave you what we thought we could do. We did the best we could under the circumstances, Denise and I, and the other 3 commissioners and Randy.
They gave it to us, thank you.
Excuse me? No, come on. It's created it. Anyway, so we came up with something that we all agree with. We all agree with you in principle on this matter. The question is execution.
Instead of the STRs of the flag.
Excuse me?
I'm sorry.
Yeah, if you all could just not interrupt me, it'd be awesome. Thank you. We wrote this ordinance because we thought it was right and good. It wasn't everything that we wanted, it wasn't everything that you wanted, but we did what we could. However, we hit some resistance that could push back on the city in some very unpleasant ways, and so we have to measure that risk. Now, whether or not this passes or doesn't pass, it's really, really a little much to have you all question our dedication to the cause here, because we wrote the damn thing to begin with. So, excuse me?
That would be up to us.
Okay, anyway, my point being is that in principle, we agree with you on almost all of this, if not all of it. However, we are trying to also protect the city's resources, and that is something that we cannot ignore. I know you all would like us to ignore it, but it would be irresponsible.
Do you have anything to add, Tom?
Okay. I just want to say and remind everybody that at this last go around that I was the tiebreaker for this and shut it down completely, just because I felt like I had my own opinions as to why I did that. Then we were ordered back to court by the judge to do this again. When that happened, right after that happened, is when our entire lives changed here on this beach. So I feel like what you all did in 2023, I know how much work you put into that, and I know how important it was. I've been preaching this since 2011, 2012 as a constituent, how and why Airbnb needed to be restricted, and what I thought would happen to our neighborhoods. It took from 2011 to 2018 before anybody did that. And from 2018 to 2023 till we got this ordinance. So I understand how much work you put into it. It means a lot to me. This neighborhood means a lot to me. I've given my heart and my soul to this neighborhood and would do anything for it. Sometimes things change, and sometimes our environment changes, and I just think that right now there are other things that are more pressing than a couple changes to this ordinance.
Wow. That's huge. Vice Mayor?
I guess one of the first things I want to make sure everybody understands is that we are very fortunate to have Randy as our city attorney, and he is very well respected. I have discovered tenfold in doing things with Florida League of Cities, how much envy goes to us when they find out we have him. So it pains me to hear some of the negative comments about him. One of the things that I think many of you sitting here tonight understand is that we're going to be fighting these issues about short-term rentals continually until something changes in the makeup in Tallahassee. Unfortunately, you didn't do us any favors in November, guys. You put the same people back there and then added a few that are even worse. So that makes me a little angry that, we get the lip service to it, but people don't follow through at the ballot box. The cost of hurricane recovery, it has obviously put us in a situation that we were not in August. The cerebral part of me says we can't afford to litigate this. The redhead in me says, oh hell no, we need to litigate this. We need to not give in to this. I just can't give up the fight.
Thank you.
Well, my comment is, you can dress this up however you want it. And the fact is the residents have spoke and said they don't want these additional ordinances added to what we already have. We've already accepted what we have and we're willing to live with it. That's what most of the residents have said. So, if you agree to it, then there's going to be more lawsuits. We're going to be an easy kickover. So that's my opinion.
Thank you, John.
Well, in my opinion, I don't see the every other year inspection as a huge deal breaker. I just don't. I know that our city staff is small, and I don't think that we're really interested in having a staff of 15 people managing short-term rental inspections and registrations. It takes a lot of time in our little office, which we don't even have right now. We're in little containers down there by City Hall. So, every other year registration, every other year inspections. I think in the scheme of things, of the $200,000+ we've spent on litigation already, to give up a couple of things like that is not a big deal. It's not. The occupancy, I can understand the concern about that. And, Randy, I think there's some confusion that 12 is going in every 2-bedroom here in IRB, and that's not true.
The question, Madam?
Yeah, there's not going to be 12 people in every 2-bedroom.
No, not every vacation rental or 2-bedroom or even 3-bedroom will have 12 people based on the language in the ordinance. It is the lesser of with a square foot calculation, and that was actually one of the things proposed when we were, both last time and and that came from some residents as well. But the language is not limitless.
And that the occupancy was sort of based on the county building code, correct?
County ordinances governing similar things have similar, though not identical, language, and that county language was used as a platform on which to develop the language you have before you. It was not without precedent or context.
And in your first mediation, they probably wanted more than 12.
They is an amorphous group of a lot of people. I think the simple answer is they don't want, if you really took it to its base elements, the extreme positions are you don't need this ordinance at all. You have noise ordinances, you have trash ordinances, just use those. The more extreme position is a version. On the other side of it is a yet more robust version of what you adopted in 2023. There's a lot of positions on the spectrum, but yes,
and that the occupancy was sort of based on the county building code, correct?
County ordinances governing similar things have similar, though not identical, language, and that county language was used as a platform on which to develop the language you have before you. It was not without precedent or context.
And in your first mediation, they probably wanted more than 12.
They is an amorphous group of a lot of people. I think the simple answer is they don't want, if you really took it to its base elements, the extreme positions are you don't need this ordinance at all. You have noise ordinances, you have trash ordinances, just use those. The more extreme position is a version. On the other side of it is a yet more robust version of what you adopted in 2023. There's a lot of positions on the spectrum, but yes, there's a motion, John, there's a motion on the floor right now to adopt the ordinance in its current form. We are awaiting if there is a second on the floor.
Not for me.
I'll second that motion.
Motion and a second. Madam Clerk, please call the roll.
Commissioner Bigelow? Commissioner Bigelow?
Yes. I need to vote?
Yeah, you do need to vote. The motion on the floor, for clarity, since there's a little bit of a lag in the audio, the motion on the floor is to approve the ordinance, amending it in the manner set forth in the agenda materials.
I I vote for the short-term rental ordinance 2025-1. I vote no.
Okay, thank you, that was a very clear response.
Commissioner Bond?
Yes.
Commissioner Wyatt?
Yes.
Vice Mayor Commissioner Wilson?
No.
By your vote of 3-2, this passes on first reading. There will still be a second reading, and for those still present or may who tune in otherwise, the second reading will almost certainly be at the February meeting of the City Commission. We will provide notice of any change.
Randy, I didn't vote.
Oh, I'm sorry, Madam
I didn't
Mayor.
vote.
I'm sorry, Madam Mayor.
Yes.
I thought I had to count.
My answer is yes.
Mayor Commissioner Osborne? Yes.
3-2. Now it has passed, and my apologies, I missed that kill.
Can we get an adjournment, please?
We need a motion to adjourn, please.
Motion to adjourn.
All in favor? Aye. All right. We stand adjourned.